Hello, everyone, and welcome. Thank you for joining Foley and Lardner for today's presentation, Working Through the Pandemic, Recognizing, Meeting, and Beating the Challenge. Before we get started on today's presentation, I'd like to go over a few CLE and HRCI housekeeping items. For those of you who are seeking CLE or HRCI credit today, please email Lauren Klippel upon joining and leaving the meeting to track your attendance. To be eligible for CLE credit, you must be logged into the Microsoft Teams meeting for the full duration of the program and complete the attorney affirmation form with the CLE codes, which will be announced later on in the presentation. Please complete this form to Lauren Klippel following the program. CLE certificates of attendance will be distributed to eligible participants approximately 8 weeks after the webinar via email. If you have any questions, please contact Lauren Klippel.
If you have questions about any of today's topics, please email them to Kayla Meister at the email address provided. This email address is also shown at the bottom of the screen and the future slides throughout the presentation. Please refrain from using the Teams chat or audio function to minimize interruptions. We will answer your questions throughout the presentation, time permitting. Of course, we will follow up with you via email should any questions arise. Please note that we have been muted at the beginning of the presentation, and we ask that you kindly keep your sound and video turned off. There will be a 5-minute break following the second presentation. For any technical issues, please try closing out and rejoining the Teams event. If problems still arise, please contact our tech team at the number provided by emailing videoconferencing@foley.com. And now I will turn it over to our hosts, Foley and Lardner partners Chris Ward and Carrie Hoffman.
Good morning, everybody. Welcome and thank you for attending and for participating in this Let's Be Flexible but Still Try to Be Productive session. It is an interesting world that we're living in this year, and it keeps on getting more and more interesting. As I say, we're thrilled that you can join us today, although to be entirely candid, also a little bit disappointed that we are not conducting this seminar at the Chicago House of Blues as we had originally planned. For those of you who were able to join us there last year for our annual summit, I hope you enjoyed it as much as we did, and we were very much looking forward to doing that again. And you'll hear later, there's still plans in the works to do it in the spring of next year, obviously conditions permitting. But just before we launch into the substance of things today, you know, one of the things that we believe in as a practice team is that there are a lot of really good labor and employment attorneys out there, and you have access to lots of great counselors. And if we want to compete in that space, not only do we have to be equally great or better counselors, but we really do need to hit that strategic partner idea and have a relationship with our client and pursue that relationship. And a big part of that for you, we think, is understanding who we are as a team, what our identity is as practitioners, who we are as people, not just who we are as lawyers. And that was a big motivator for why we decided to start doing this format in the House of Blues in the first place, is that, you know, it does provide for a casual environment, but still one that was good for learning and good for networking and all of that good stuff. And we don't have that opportunity today, obviously. So we wanted to talk a little bit about a different aspect of our identity, just again, to give you a flavor who we are as the United Foley and Lardner Labor and Employment Team. And so to talk about that in particular and what we've seen in 2020, I want to briefly flip over to my partner, Phil Phillips, our managing partner in the Detroit office, to talk about some diversity and inclusion concepts and how that relates to identity at Foley. So Phil, take it away, please.
Thank you, Chris. Can you hear me okay?
I certainly can.
Thank you. Thanks, everyone. I just wanted to take a very brief opportunity to discuss Foley and Lardner's diversity and inclusion initiative. One of the firm's core values is our commitment to our people and to diversity and inclusion. Several years ago, Foley adopted a very comprehensive and involving diversity and inclusion strategic plan, which focuses primarily on ensuring that all of our attorneys are given the tools and an equal opportunity to exceed at the firm at all levels. And part of this diversity and inclusion commitment includes understanding the value of diverse teams of attorneys, bringing those diverse teams to our client relationships, and ensuring that we look like our clients. Not just because it's expected of us from our clients, because we understand it's just the right thing to do, and having a more diverse team certainly brings value to the type of legal advice we're able to provide our clients. To say we're living in challenging times now, as Chris already touched on, would be an understatement, not just when it comes to COVID, but when it comes to the racial injustice and issues we're seeing across the country. Foley's commitment to diversity and inclusion extends beyond the doors of the firm, because we understand that to be true to our core values, we know we must also be committed to doing the difficult work necessary to combat racial prejudice and effect real change in our communities where we live and where we serve. As part of Foley's effort to join this fight for racial justice, and as part of our D&I initiatives, we've taken a number of steps, multiple steps. Just a couple of them I want to just briefly touch on. The firm joined the National Law Firm Anti-Racism Alliance, which is an alliance formed by multiple national firms and smaller firms across the country. The firm's management committee that's charged with setting policy and the strategic planning for the firm for the future adopted a number of recommendations based on input from the Black Attorneys Affinity Group at Foley, and recently approved a number of actions and steps to help prove and move our diversity and inclusion plan forward, and to help combat racial injustice in our communities. Another thing we did as well is the firm created a national pro bono racial justice and equity practice group, which is really designed to, on a pro bono basis, handle various matters across the country involving unfair and unequal treatment based on race or ethnicity. This new pro bono practice group also gives us an opportunity to collaborate with our clients, which is something we've done in the past on different pro bono opportunities. And probably a number of the clients here on the phone have also joined us in these particular efforts. So those are the things I just wanted to briefly touch on. We understand that there is much work to be done, and we still have a long way to go. But we are definitely optimistic fast in our commitment to doing what is right within the firm as well as in our communities. And with that, I'll turn it over to the next set of presenters.
Hey, good morning. So my name is Scott Allen. I'm an associate in our Milwaukee office. Today is actually my 6th year anniversary of working at Foley since 2014. And I'm going to start our presentation talking about where we have been since the pandemic hit. And I'm going to be talking about COVID-19 issues, I guess, realizing that we could spend hours on this. So I'll try to condense kind of the key things that have happened. And there's certain topics that I know a lot of you are interested in, including remote work and returning to work. And some of that will be discussed in a little bit more depth later on. So just as an overview, obviously the pandemic has just created unprecedented and unique challenges for employers. So in March and April 2020, most states issued stay-at-home orders, which resulted in non-essential businesses not being able to be open unless the work is remote and from home, which has led to mass layoffs and furloughs. There's issues of employee health and safety like we've never had before. And given all the layoffs and furloughs, there's been a record number of unemployment claims. And there's also been, workers' compensation claims as a result of, people getting ill from COVID-19. So it's really something that employers have not faced really, and anything, quite like this, I think, in our memory. another aspect of this that we're going to talk, later presenters are going to focus on this is, paid leave mandates. The biggest, legislation out of Washington was the FFCRA. That's the Families First Coronavirus Response Act. And that generally required all companies with less than 500 employees. So it's one of the few laws that only applies to smaller businesses, but it required that employers provide paid leave to people who need to miss work to quarantine because they're sick with COVID-19 or to care for children whose schools have closed. So that's been one of the big developments in the paid leave aspect. Just overall, there's been a lot of federal, state, and local regulations, everything from, what the CDC has put out, which we'll talk about, as well as, just states with, orders requiring face masks. There's just a whole bunch of, issues that have come out of this that employers have never had to deal with before in normal times. So starting with, what's come out of our federal agencies, the leading agency that has been, issuing the government's recommended guidance and steps to take for COVID-19 is the CDC. So that's the Centers for Disease Control and Prevention. The CDC's guidelines they're not, binding, and the CDC itself doesn't issue fines to employers or do anything like that, but it's really been OSHA, the Occupational Safety and Health Administration, as well as, state and local health departments that have adopted, CDC's guidance and enforced them. So the CDC has been the leading agency kind of with putting out what the latest recommendations are on what people should do in terms of everything from wearing face masks, which you might remember the CDC actually did not, it took weeks into the pandemic. It was April 3rd when the CDC, changed what they had previously. They said that they did not recommend wearing face masks, and then April 3rd, everybody is encouraged to wear face masks in public. And a lot of the other guidance that they put out has evolved since we've learned more about the disease. The guidelines that the CDC has, a lot of this will sound familiar to you, but it's, encouraging employees who are sick to stay home before allowing people on site. The CDC recommends having health screening questions, confirming where an employee has been traveling, and confirming that they don't have symptoms, or their family members don't have symptoms, as well as doing temperature checks and physically screening employees before they're allowed at the workplace. And what's also recommended, by the CDC and OSHA is having flexible policies so that obviously if somebody is sick, they should stay home. And I think that's something that employers have, universally adopted, and just encouraging people to practice social distancing, to wear a face mask when they're in common areas, and to clean the facility or workplace, and have regular cleaning and disinfecting. And these guidelines have changed over time, as I mentioned. So currently, one of the more recent changes was that somebody who tests positive for COVID-19, it's recommended that they quarantine for 10 days rather than 14 days. But that period can go up to 20 days for somebody who has a severe case of COVID-19. And just the latest, we have several U.S. senators who have appeared at nomination, the Supreme Court hearing yesterday and today, who did test positive, and the rationale for why they're back in public has been that they've quarantined during this 10-day period, and under the CDC guidance, if they do not have a severe case, they should be asymptomatic by now. So as I mentioned, the main agency that's actually federal agency that's enforcing these rules is OSHA, and a lot of states, including California, Michigan, Indiana, and some others have have state programs that so like OSHA is a California agency that enforces OSHA rules. And there's been no actual new regulations that have happened, but instead OSHA has enforced what its existing rules are on bloodborne pathogens, which has a lot of rules for healthcare employers, personal protective equipment, and sanitation. So there's a lot of rules that are already in place that employers are expected to maintain a safe workplace and to keep it clean. And those are the rules that OSHA has been enforcing on the COVID-19 area. One thing that has come up a lot is the issue of PPE. So cloth masks or ordinary face coverings that you wear at the grocery store, that's technically not considered PPE according to OSHA. It is still a best practice to require that, and it's in many states mandated in workplaces, especially where employees cannot maintain distance. But this is the big enforcement area for OSHA, and it's been for the most common violations so far that they've issued, and it's been to healthcare employers over the face mask rules and respiratory protection. So employers that require N95 masks or similar respirators, particularly in the healthcare setting, are required to have a written program, fit testing, medical exams before people can wear face masks. And that so far to date, that's been the most common violation that OSHA has. And typically what I think most of you have been, if you've dealt with OSHA, it's likely been what they'll typically do is that there'll be an employee complaint that says, my employer is not cleaning enough or is not enforcing social distancing, and OSHA will send a letter to the company and say, hey, this is what the allegation is. Please, give us, correct this issue and let us know, what the result is, if you give a satisfactory answer, OSHA, in less than 10% of cases, ends up doing an inspection. So what I know a lot of companies have dealt with OSHA dealing with that. Typically, you can just tell OSHA, hey, this is everything that we've done. We require face masks in common areas. We clean on a daily or on a regular basis, and here's our evidence. And ordinarily, you're not going to hear from OSHA after that. What OSHA has been prioritizing, again, is the healthcare industry, and also, especially with a lot of the meat, poultry processing plants, areas where they've had a lot of outbreaks. That's something that OSHA is more likely to conduct an inspection into. So another big category of violations that has come from OSHA's enforcement has been on reporting incidents to OSHA, and also recording incidents on your OSHA 300 log. So any manufacturing employer, except for low risk type industries, generally are required to keep a log that has all illnesses. So with COVID-19, what OSHA has said is that you're required to, any positive COVID-19 case, employers are required to conduct an investigation to see whether the person got it at work. So if it's one person, if it's not a cluster of employees, but it's just one worker who shows up tested positive, ordinarily you're not going to be able to tell where that person got exposed. But what OSHA requires is that you do an investigation, which would include looking at interviewing the employee, finding out where he or she has been, who they work near, and asking questions like, where have you, over the last 14 days, where have you been? Has anybody in your family gotten symptoms or tested positive? And, have you been wearing a mask? And, who have you been in close contact with over the last, 2 weeks? Once an employer does that, as long as it's a reasonable investigation, and if at the end of it you can't tell one way or the other, which usually was the case. They could have gotten exposed at the grocery store. It could have been, you really don't know where it is. If that's the case, OSHA said you're not required to put this on the OSHA 300 log, and that's so most cases that we've advised on, that's ordinarily the case, but particularly if you get a cluster among people who work together, in that case, you may determine that it's related and have to record it. And another issue that comes up is any inpatient hospitalizations are required to be reported to OSHA, and you're also expected to report fatalities. So for employees who work at home, this isn't an issue at all, because if they get exposed, it's from the home environment and not work. But whenever you have somebody who becomes hospitalized or, unfortunately who dies after contracting COVID, employers need to do the same type of investigation that I mentioned. And once they determine that that employee, once they find out that the employee has died or is hospitalized, there's a general rule you're required to report it within 24 hours for hospitalizations and 8 hours for fatalities. OSHA has just put out additional guidance, which makes this issue even more tricky, which says the hospitalization only needs to be reported if the person was hospitalized within 24 hours of exposure or died within 30 days of exposure. And what we have generally, counsel clients and urge them to consider is you can report something to OSHA out of an abundance of caution, even if you can tell OSHA at the same time, hey, we do not believe that this employee, this person was hospitalized, and we don't believe it occurred at the work environment, and here's why. But out of an abundance of caution, we want to report it to you so that it doesn't become an issue. And typically OSHA will appreciate that. So if you have a situation where somebody is hospitalized or unfortunately dies, I think it's important to consult with legal counsel and decide, whether do the investigation and decide whether it's something that you should report, even if you disagree that it's something that needed to be reported to OSHA. So the next area that I'm going to talk about is state and local regulation. So this has varied quite a bit. There has been, as you recall, from March and April, there's 43 states that issued stay-at-home orders. And what these did is they closed all non-essential businesses and generally restricted travel and only allowed people to leave their homes for to go to the grocery store, for exercise, or for certain reasons. And generally, and there's only 7 states, which are generally rural states, did not issue orders. And we're at the point now where some of the stay-at-home orders have expired. Other states have just gone through phases of reopening. So the amount of what an employer is allowed to do, whether have people work on site and what types of workers can be on site, really depends on what the what phase or the state or locality is in and what the particular regulations are. So one example is in Minnesota, there's a, the executive orders are pretty strict, and they say, anybody who can work from home must do so. And there's other states that have similar language. But in order to determine, can my business require everybody to go back to work, let's say you want to do it in November, it's really going to require looking at what are the regulations in place in your state and the locality. And if there's no order restricting it, maybe that's all you need. But for a lot of them, particularly, and I know Minnesota, probably California, and other states that have pretty restrictive measures, you need to look at what type of work does the person do, and really intelligently think about how are you going to reopen and who's going to be allowed to work at least on site and not remotely. Another issue, obviously, that's come up is 33 states have issued statewide mask mandates, and what those typically require, like in Wisconsin, that one says you need to wear a mask if you're in any public space or any indoor space. Basically, if you're indoors, including at work, unless you're in your own office with the door closed, you need to have a mask on. So that's how Wisconsin has done it. And that's just another issue that is emerging among the states. So I wanted to talk more in depth about Wisconsin. I think Michigan is another one that had similar developments, but there's been a lot of legal challenges to stay-at-home orders and to mask mandates, particularly in states where there's been divided government. So Wisconsin has a Democratic governor and a Republican legislature. And so there's just been a lot of uncertainty around orders and developments on that front. So Wisconsin issued a stay-at-home order in March. That order got extended, and the state Supreme Court struck it down as unconstitutional on May 13th. So then starting in mid-May, you had to look at, there was Milwaukee, other Madison and areas in southeast Wisconsin enacted their own regulations to look at because there was no statewide order. And since then, Wisconsin has issued a statewide mask mandate, and the governor just recently issued an order requiring, it doesn't apply to like manufacturing facilities, but stores, other indoor places open to the public are limited to 25% capacity. And these recent orders have been challenged in court, and they're still going through that process. And the same thing has happened in Michigan, for example. The state Supreme Court held recently that the governor's COVID-19 orders were all unconstitutional after I think it was April 30th, the temporary period that once they got past that, the emergency ended, and they needed the legislature to act. So this has been a particularly contentious issue, and something that has been in areas where there's been kind of divided control of state government or state and local government. This is a issue that continues to be contentious about, what authority does the state government have to issue regulations and, and do all of that with COVID-19. So with that, I am going to turn it over to my colleague Jessica Mason, and she'll carry on this discussion about COVID-19 state regulation and talk about leave laws.
Hello and good morning, everybody. I am very happy to be here with you this morning. Thanks for your time. So as Scott mentioned, I'm going to pick it up here by discussing some of the leave laws. We've referenced, and I think everybody has a good baseline by now on the federal leave laws that Scott referenced, things like the Families First Coronavirus Relief Act. But since that only applies to a certain subset of businesses, many states, many cities, in fact, have taken an active role in creating additional leave opportunities as a result of COVID-19. As you can see from this map, which I color-coded because if you know me, of course I did, many states have either created whole new laws relating to leave for COVID-19. Many states have modified existing leave laws for COVID-19. And of course, some cities and municipalities are getting in on the action too. The big distinction between COVID-19 leave and leave allowed under the general FMLA or state FMLA laws is it's much more expansive, and it's designed to specifically attack the issues that arise relating to COVID. For example, if you don't test positive, but you have to quarantine, or if your family member is quarantined or tests positive, then you need to not go to work. Likewise, if there's a situation where your child is out of school, some of these leave laws give you the opportunity to take time away from work to manage your child's schooling. So these items of caring for others and caring for school is a big break from the previous leave and paid time off structures. Some of these laws do require paid time off. By and large, the states and cities that require paid leave for COVID-19 had a previously existing paid leave or paid sick time law. So most of those jurisdictions have simply expanded the ability to use that paid sick leave for issues and absences relating to COVID-19. While there seems to be clusters around the country where legislatures have taken this action, we have to remember that when we're talking about state action, state legislatures are not like the federal legislature, which is generally in session throughout the year. Many states have legislatures that only meet for very specific times, and it's very difficult to convene a legislature on this stuff when they're not otherwise in session. A good example of that is Texas. Texas state legislature is only in session in odd number years. So we basically been out of session the entire COVID pandemic. So we expect that Texas is going to look at some of these items when they convene in 2021. Now, what they'll do, any of these states will do, is anybody's guess. My magic 8-ball is telling me to ask again later, primarily because, for example, in Texas, they don't convene until January, and nobody knows what the landscape is going to be in January. But it's definitely one to keep an eye on. As a sidecar to Scott's discussion about OSHA, which is of course the federal laws relating to workplace safety, each state does have a workers' compensation regime. As most of you know, workers' comp is an insurance program whereby employers and employees have a trade. The employee trades away his or her right to sue the employer for negligence and errors, and the employer gives away its right to defend itself against some of these more common claims. Of course, gross negligence, really bad conduct, is never covered by comp, and that's an important thing to remember as we look at it through COVID-19. Most states have historically excluded a, quote, disease of life. A disease of life are things like the flu or common cold even, where you can get it anywhere and most people typically get it somewhere or another. Another example that's more often contested is cancer. Many people unfortunately get cancer. Some of them get it from work. So unless you can clearly establish that work-related nexus, they're not covered. COVID-19 has changed that, particularly for jobs and industries where there are high personal contact. Of course, that means medical and healthcare environments, but it also means retail and food service environments, the grocery store workers, the restaurant workers. The fact that they are out there in public because we are asking them to be means that the state is going to give them a little bit of an easier road to getting coverage if they do get COVID. In most states, though, it is a partial coverage. Very few states have a blanket coverage for COVID, although some do. For example, Connecticut and California, they do have a rebuttable presumption that if a worker gets COVID, it may have been at work. A rebuttable presumption is one where the workers' comp board is told to assume this unless they show you otherwise. So the employer then has to show that they did not get it at work, which can be tricky. Other states have changed their laws to increase coverage for this, but only for a limited time. For example, in Wyoming, only for calendar year 2020, but they've expressly included COVID-19 as a covered disease, taking it out of that disease of life and putting the burden on the employer to prove that they didn't get it at work. A number of states presume coverage, but it's not as, there's different standards. And so in most states at this point, if an employee can show that they got the disease at work by showing their only rational exposure was at work, it's typically going to be covered. Now, one thing to think about is we want to be consistent. When you're looking at the workers' comp question, what are you doing with response to your OSHA question? You want to be consistent. If you're reporting to OSHA that there has been an exposure or a positive, you want to go ahead and make sure you're reporting that to workers' comp too. On the flip side, if you make the decision not to report it to OSHA, you're not going to want to report it to workers' comp. You're going to want to stay consistent. Finally, at the federal level, the Congress is looking at creating an insurance fund for COVID comp issues, similar to the framework that they created for the Terrorism Risk Insurance Program. What that does is it shares the burden on any employer, essentially across all employers, where because this is a national pandemic, they're looking for a national response. And one employer, say a poultry plant like we've seen get hit particularly hard, that industry becomes at such a high risk where it serves all of the country. So they're looking at finding ways to share that insurance burden. The top question on this on many employers' mind are, can we ask our employees to waive liability relating to COVID? And in reality, most of us has probably signed something like this, whether to send our kids to school or something else at some point. Unfortunately, or fortunately, depending on how you're looking at this, these waivers are generally ineffective. Some states are taking more aggressive action, such as Iowa is a good example. They are the most aggressive state in the union in protecting employers against liability relating to COVID. Essentially, an employer in Iowa cannot be sued for COVID contact unless they were reckless or disregarded the most basic rules of protection. Other state legislators are taking a slightly more moderated approach and say that if you as an employer, you're complying with the CDC guidance, you're complying with the state guidance, and you are trying to be a good workplace, a safe workplace, they're going to put some protections in place. And you can see the list of states that have already done that on the screen. They too, though, don't protect against reckless behavior or any sort of disregard of basic rules. And because the scopes of protection will vary, every employer should be taking at least the basic precautions that we've discussed and will continue to. This is to protect you from liability, but also to protect your employees. Some of the workers' comp regimes are also taking a look at how this is applied in real life. Some workers' comp states have said, okay, in some industries, we're going to expand coverage beyond other industries. Medical, healthcare, retail, we know that this is a high-risk environment. We're going to expand protection. Another discussion in a lot of states is whether, if there is a COVID positive or a COVID, should that be included in the employer's experience rating? And states are looking at this from a lot of different angles, and a number of them are concluding in their workers' comp boards that it should not be included. The reason is they want to encourage people to report to help ensure that people get care. Also, it's really not as much in the employer's ability to control. So turning away from these issues, we've seen, again, a lot of state and local regulation. Local regulation has been most active on paid leave throughout the country. They have been most active on opening and closing, determining who is an essential worker and when they can work. And also, most importantly, are mask regulations. Very few states at this point have a mask mandate. Many state and local cities have them. And the states that have them often allow the businesses to require them. So it does give a lot of local control. This is good because in a state like Texas, which is huge, you can have Houston that has one situation and El Paso, which has another COVID situation. And those cities should be able to treat this issue differently. Biden has been campaigning quite a bit on a national mask mandate, on national rules of engagement in public as it relates to COVID, meaning how retail employees would work, what types of PPE and protection. So in addition to the PPE that Scott referenced, things like plexiglass shields that we see in the grocery store. These are items that are teed up at the federal level. Some of these are being discussed as Congress mulls its way through potential legislation. That includes higher level things like employer liability protection and workers' comp pools, but we still have to look at it at a narrower scope. When it comes to testing and vaccines, this is a really common question. And when employers ask it, the answer is almost always, because we're lawyers, it depends. Why do you want the information? And what are you going to do with it? So the EEOC has said that during the pandemic, employers are permitted to do mandatory COVID-19 testing. And this could be a good idea if there is a cluster that an employer is trying to address. It seems to be less useful if it's just a blanket check of all employees with no particular spur. The reason for that is because a person can test negative today and become positive or test positive tomorrow. So mandatory testing can be a useful tool for employers, but it should not replace social distancing, good hygiene, masking, those day-to-day steps that we can all take. The next common question is mandatory vaccines. And when employers ask, should I mandate that my employees get the vaccine? I always tell them to slow down because we don't even know if we're allowed to do that yet. It took an act of the EEOC to tell employers that they can even test for COVID. Requiring vaccines is going to be a whole nother step further. Candidly, we don't expect very fast action on employers mandating vaccines or even allowing employers to mandate vaccines from the EEOC. Vaccines is a pretty hot button issue in general, and given the very challenging political landscape of COVID, it's unlikely that the EEOC is going to say that employers can mandate vaccines, but we've got to wait and see. Meanwhile, back in DC, the DOL in 2020 has actually been doing its own work. More than just COVID-19 issues have been before it, and they're still trying to sort out some of these really common issues that we've been seeing for the last few years. The independent contractor question, there has been a rule proposed by the DOL because the comment period is still open. We don't know what the final rule is going to be, but the DOL is currently looking at dialing back the requirements to be an independent contractor. We see this most often in the gig economy, and the most famous example is California's ruling on Uber and Lyft drivers. But independent contractors are used in almost every industry in America, so it's a really common issue. The DOL is proposing a reality-based test, which is two key parts. One, same question it's always been, who controls the work? If the employer controls the work, then they're probably an employee. If the worker really has great control over how to do the work, when to do it, where to do it, and are really more focused on the final product, the deliverable, then they're likely to be an independent contractor. Another test that the department is encouraging the adoption of nationally is the economic reality test. This is a test that has been used by a number of circuits for the last several years. And the question is this: are you economically captive to the employer? If you truly have an independent business and have time away from this employer to go earn money elsewhere, you're more likely to be an independent contractor than you are if you are really economically dependent, economically captive. Because if you don't, even if you don't have time, you're working 60 hours a week for this employer, you don't have time to go earn money somewhere else. Those are some new tools that are being used, and we're going to have to see how those play out. Joint employer status is another big change in 2020, and the department really narrowed the focus of this question. Joint employer status, first of all, is when two different companies will share the ultimate responsibility for employment law compliance with respect to workers. We see this very often in companies that utilize temporary agencies or staffing agencies, or, for example, in some industries where there's a number of companies out on a given work site, like in the construction industry. So to determine if you're a joint employer, you're going to look at four things. One, who has the ability to hire and fire? Two, same question, who controls the work? Who supervises the schedule, the conditions of employment? Three, the rate and the method of pay. He who controls the money controls the employee. And finally, the maintenance of employee records. All of these are going to be looked at together to paint a big picture. No one factor is going to rule the day, but the department suggests that we would take a look at all of this to see who has ultimate responsibility. That way, if it's your employer, if you're a joint employer, you're on the hook for wage and hour laws, for leave laws, for OSHA laws. So you definitely want to be aware of this. Finally, and something that was initiated prior to COVID, but does have a significant COVID impact, is this ability to pay employees additional money, particularly salaried employees. There has been an open question of how and whether you can pay employees more without losing the exemption when they're exempt. And in particular, there's a fluctuating work week method. It's a very complex method. It's a lot of math. We're not here to do math today, but essentially it is a wage structure where an employee who works a varied number of hours each week gets paid a fixed salary, then receives a half-time premium instead of that time and a half for the extra hours, all the overtime hours. So they get their salary, and then for every hour worked in excess of 40, you get that half-time premium and not the time and a half. So this results in great savings. Overtime's a lot cheaper for employers, and employees get the consistency of that salary even if they work less than 40 hours. So it's a trade-off. The big issue here is that if an employee is paid hazard pay for COVID-related items or any other reason, if they're given a bonus or any kind of discretionary payment, then they can use that without losing the benefits of the fluctuating work week. And more specifically, as it relates to COVID, time off is really the question of the day. Employees are needing time off because they're positive, they're on quarantine, their kids are in school, there's a million different reasons. The guiding principles here is there should be generous use of PTO. If you have vacation time, consider allowing people to use it as sick time. If you have sick time, allow people to use it for quarantine or school time. The goal is to support the employees with this benefit that they've already accrued. The biggest challenge, though, comes with unpaid time and managing exempt employees. exempt employees have to be paid their full salary in any week in which they do any work. Otherwise, you lose the exemption and you got to go back and pay them overtime for what they might have worked in the year. So it's really important. So if somebody works on Monday and is out the rest of the week because of COVID quarantine or school started, they still have to be paid their full salary. You can use PTO, but it's very tricky to take pay away from exempt employees. There are rules that allow you to do it, but you got to be careful. It really comes up in a furlough situation. If you have an exempt employee and you say you're going to be furloughed on Tuesdays and Thursdays, you've got to pay them for the full week because they're still doing work on Monday, Wednesday, and Friday. So if you want to take this approach, it's really important to be thoughtful going into it. For example, you want to have a full week of furlough and make sure you're starting it at the same time as your pay week starts. That way you don't have to pay them. If you start the furlough in the middle of a pay week, even if the furlough week is a calendar week, you're still going to be on the hook for that pay. And finally, the DOL helpfully clarified that as employers are slimming down in this economy, employees can be asked to do work that is outside of their regular duties. And most importantly, for exempt employees, the DOL is dialing back how it's looking at that primary function. Typically, exempt employees have to be very cautious about not performing non-exempt duties, or you could lose the exemption. At this point, the DOL is saying you got to do what you got to do to get the work done, and exempt employees can take on more non-exempt tasks without losing the exemption. And then finally, the biggest complexity that exists in wage and hour seems to be managing remote work and making sure that you pay for all of it. The law says employers have to pay for all the work an employee does, which is kind of easy when they're in your office and you can see when they're there and you can see when they leave. But when everybody's working from home, it is a lot to manage. So what's important is that an employer has to pay for all of the time that you know an employee worked. That means if you actually know that they are working, you're Skyping with them, you're IMing them, or you're getting your work product. Also, if you have constructive knowledge, that means you maybe don't know for sure, but you have a reason to be aware. For example, you didn't know whether or not they worked on the weekend, but you gave them a project on Friday afternoon, and they, being the wonderful employee that they are, turned it in on Monday morning. That's some knowledge that they did the work over the weekend. At the same time, you are not required to investigate everybody's hourly work. Finally, the last slide, and I lost the slides. I'm not sure about y'all, but the last item here is when people are working extra time, the biggest item to note is that you cannot fail to pay them because they are no longer, because you told them not to work the overtime. Even if the overtime was unqualified or not pre-approved, you still have to pay them for the time that they worked. And it doesn't matter if you have a great explanation or a great reason for not paying them, it doesn't matter. It's strict liability. That means it doesn't matter the reason. If they worked and you didn't pay them, you're on the hook. With that, I'm going to kick it over to our colleague, Ryan Parsons, who's going to start chatting about labor law.
Thank you very much, Jessica. Thank you also very much, Jenny, for getting the presentation back up. I pushed a button. I don't think I turned it off, but it's always possible. So when we were doing this presentation and wanting to talk about kind of where have we been, obviously a big focus has been on COVID, and Scott and Jessica have talked a lot about that. We also wanted to look at other developments in the law. Quite frankly, most agencies, most courts have slowed down their non-COVID related output since the pandemic. One agency where that has not been the case, though, has been the National Labor Relations Board. And there's really a good reason for that. It is a partisan board. It's a 5-member board where 3 members are controlled by, or 3 members are nominated by the president's party, and 2 members are nominated by the out of power party. So of course, with President Trump in office, there's 3 Republican members, 2 Democratic members. Because of that, it's inherently partisan. It's designed to be partisan. And the result of that is there's always kind of this ticking clock. Anytime there's a potential change in power, the NLRB wants to get as much done as it can before that change in power occurs. And that's really happened here. So, there is this tension between, wanting to slow down as a result of the pandemic, but also wanting to get as good stuff out there, and, for management side lawyers, as management-friendly rules as possible out there before, the clock strikes midnight in the event that Vice President Biden is elected next month. So we'll talk a little bit about how that's playing out in a number of different areas. In addition to all that, there is this ongoing fight between the board on one hand and House Democrats on the other hand doing an investigation. Just like the Department of Labor issued a new rule on joint employment, the NLRB did the same recently. Originally, it was done through a decision of the board, revising an old Obama rule, and we'll talk a little bit about that going forward. But after that, one of the members had to recuse themselves from the case, so they had to rescind the order. And instead, they went forward with a new rule. They established a new rule on joint employment through the rulemaking process rather than through a court decision. And the member who participated or who had recused himself from the case participated in the rulemaking. House Democrats are accusing that member of a conflict of interest, and they've subpoenaed documents relating to the investigation. The board is claiming executive privilege, and so they're going back and forth, and there is this pending subpoena that's out there right now. So pretty much par for the course in terms of conflict between the agencies, between the parties in Washington right now. On a regional and local level, kind of contrasting with what the national NLRB is doing, it is similar at a regional local level to what we're seeing in other areas at the NLRB. Both investigations and elections have been slowed down as a result of the pandemic. It's obviously more challenging to do in-person investigations. Historically, elections are done in person in a secret ballot. That's more of a challenge as well. So we're seeing the NLRB, like other agencies, move more toward virtual proceedings. So I know next month I have an NLRB unfair labor practice hearing scheduled that normally would have been a 2-day in-person hearing. We're going to try to do it all, via Zoom, and with all the challenges that entails. Putting a witness under oath, introducing exhibits, all these things that you take for granted when you're in person. We're going to be trying to do virtually. In addition, arbitrations are proceeding virtually as well. A lot of times, employers are often an employer is objecting to participating virtually, but with cases of both labor arbitrators and the NLRB, they're basically overruling objections and looking to proceed virtually as much as they can. So let's talk a little bit about the kind of recent updates in NLRB rulemaking and decisions. There's a couple of recent decisions issued here in the last couple months that have been, again, very employer friendly in what very well could be the last year of what we would call the Trump board. Overturning Obama board era precedents. The first one is the General Motors case. And what the General Motors case did was it addressed the example of an employee who gets discipline when he engages in a variety of conduct, some of which is protected under the National Labor Relations Act and some of which is unprotected. So think, for example, an employee who's complaining about his wages, or even in the COVID environment, an employee who's complaining about unsafe working conditions. That is protected conduct under the law. However, if the employee also cusses out his supervisor, knocks over machinery, gets into a fight, that particular method of opposing the unsafe work environment is not protected. So what do you do when you have an employee who has some protected activity and some unprotected activity, and the employer disciplines him for that? The NLRB adopted a traditional burden shifting standard under their longstanding right line case. So the prior test involved, a number of factors, looking at it, the time of the conduct, the nature of the conduct, looking at all these different factors and trying to balance them out. The NLRB said, no, that's no longer the rule. The new rule is we look at the employee. The employee has to establish a kind of a prima facie case, a facially persuasive case of discrimination to show, A, they engaged in protected conduct, B, the employer knew of the protected conduct, and C, the employer had some level of animus for the protected conduct. If the employee can show that, then the burden shifts to the employer to say, well, even if all that's true, I would have terminated the employee anyway because of the unprotected conduct, because he punched a supervisor, because he cussed out a supervisor, whatever it is. So in that case, the burden shifts to the employer, and the employer has to justify the termination, basically. The new decision is helpful in the sense that it gets rid of this kind of burden shifting test, or it gets rid of the balancing test that makes it a little bit more kind of linear in terms of proving the case. And again, I think particularly this NLRB, the Trump NLRB, is going to be very deferential to an employer that says, no, I fired the employee because he punched his supervisor, even if it's in the course of otherwise protected conduct. The other recent case that the board issued was 800 River Road, and what that does is it shifts the meaning of what an employer is allowed to do shortly after a union is certified, a new union. So when an employer becomes a unionized employer, it has an obligation to maintain the status quo, right? You can no longer make unilateral changes. You can't give employees raises. You can't change employees' shifts around ordinarily without first negotiating with the union. But what the 800 River Road decision says is, well, yeah, we have a status quo, but it's a dynamic status quo. And so what that means was, if the employer regularly did something before the union was elected, then the employer is still allowed to do that thing until the parties negotiate toward a contract. So in this case, if the employer had broad discretion to issue a range of discipline for a particular piece of misconduct, the employer still has that right until the union and the employer reach a new contract. So it's a pretty narrow case in that it only applies during this pre-first contract period, but it does give employers a little bit more flexibility to maintain their workforce while they're negotiating toward a new contract. Another early union certification issue is the election rules that the board has rolled out. You may remember that in 2015, the Obama board issued new election rules that really sped up the process. Sometimes called quickie rules, sometimes management lawyers call them ambush rules, that very shortly after a union files a request for an election, you advance to an election. So historically, the period had been about 40 days. And a union files a petition for an election day 1, the election occurs roughly day 41. Under the Obama era rules, that sped up from employer now filing a petition on day 1 and an election going forward on day 16 on average. So it sped up the process by about 25 days. And as a result of that, employers often struggled to campaign on those terms. The union may have been, soliciting employees, building up support over a period of months prior to the certification. And then the employer feels like, oh, I don't have a chance to really tell the employees my side of the story, given the quickness with which the elections turned around. So the board basically issued rules that kind of restored some of the old status quo prior to the Obama revisions. And those were set to go in, those were rolled out late last year, set to go in effect, I think, June 1st this year. Right before that, a court issued an injunction postponing some of the bigger changes. So one of the ways, for example, that the NLRB slowed elections down was if employers had objections to the particular bargaining unit, or whether particular employees got to vote or not, they got to litigate those issues before the election, which had the effect of delaying the election. The court enjoined that rule, said, no, we're not going to do that. We're going to stick with resolving those issues after the voting. And there's a handful of others as well. So the board went forward with the rules that were not enjoined by the court. Those went into effect June 1st. So now we're in kind of this hybrid system where some of the Obama era rules are in effect, some of the new rules are in effect, and the injunction is currently on appeal. So it remains to be seen how that's going to be resolved. So what is the NLRB looking at doing prior to January 20th, January 4th, 2021? it has a couple of rules that are standing out there right now. So one of the rules is on the elimination of the pre-election requirement that employers give unions information on employees' personal phone numbers and personal email addresses. This is another great example of how the law can shift. Prior to the Obama board, employers had a duty to give employers had a duty to provide to unions prior to an election in the personal phone numbers. In the Obama board, they expanded that to include personal email addresses. So if you, employer, had an employee's personal email address, you were required to disclose that to the union in advance of the election. Now, the Trump board has proposed revising that, and so not only eliminating the email requirement, but also eliminating the personal phone requirement. So now they'd only have to give out personal addresses. The stated rationale of the board for for revising the rules in this way is that the current rule does not adequately protect the privacy interests of employees, that employees are not protected from unwanted solicitations from unions and getting what they would say getting harassed by unions in advance of an election, allowing unions to pressure employees, while they're at home, via email, via calling them, texting them, what have you. Of course, this rule would also make it harder for unions to contact employees prior to an election, which, if you're looking at it from a cynical point of view, is certainly good from the management lawyer perspective of the current majority of the NLRB. The other pending change is a provision to give absentee ballots to employees who are on military leave in advance of an election. Again, ostensibly the rule is designed to allow people who are serving the country to also have the right to opine on whether their employer should, whether the employee should form a union. Again, cynically, however, if someone is serving overseas, it raises the question of how long it'll take for that absentee ballot to come back in. Will it necessarily delay the election? Will that have an advantage for employers as well? So depending on how you want to look at it, there are certainly pure and cynical motives for these kind of new rules. In addition to that, there's a relatively important pending case called Mount Air Farms, where the NLRB has sought input from interested parties on modification of what we call the contract bar doctrine. So what the contract bar says is during the first 3 years of any collective bargaining agreement, the union enjoys an unrebuttable presumption of majority status. So if you have a 100-employee union and you have a contract in place, and every single employee comes to you and says, I want to get rid of the union, what can we do to get rid of the union? I just want them to go away. If you're within the contract bar, doesn't matter. You cannot get rid of the union during those first 3 years of the contract, except in a very short window prior to the end of the contract. And so the NLRB has now solicited legal opinions from unions, from employers, from whoever wants to give an opinion on whether they should modify that doctrine at all. Again, we would expect this board, if they were to issue this decision prior to the end of the term, to probably erode some of the contract bar, if not eliminate it entirely, on the grounds that it does limit employee free choice. But again, all of these changes, all of these potential decisions, all of these recent decisions, they all come with an expiration date. This is a flip-flop from what was going on in the Obama board. If there is a Biden board come 2021, it's likely that they're going to do a lot of the same things to undo what the Trump board did. So even for those of you employers who are non-union, who are lucky enough not to have collective bargaining relationships, just keep in mind that a Biden board may be more likely to intrude themselves on non-union workforces, as we saw in the Obama board. One of the things we saw in the Obama era was really going after employee handbooks, really inspecting, fly-specking rules for things that could potentially chill union rights or organizing rights or protect concerted activity. The current Trump board has really gotten away from that, but we would certainly expect a Biden board to re-examine some of those precedents. As for how the pandemic affects your union obligations, Cam Merafferty is going to talk about this a little bit more, so I won't go into too much detail. But just keep in mind that most normal rules still do apply during the pandemic. The NLRB General Counsel issued a memo, with the examples set forth in these bullet points. If you're laying people off because of COVID, you can't just lay off the people who like the union. If employees are complaining about safety, you can't retaliate and discipline against them for complaining about safety. You still need to provide information in response to information requests, just as you would without the pandemic. There may be some limited exceptions to that. Especially in the early days of the pandemic, employers may have had some ability to unilaterally implement terms without negotiations, if needed. Especially you think of things like shutdown orders. If you get a shutdown order that requires you to close your operations, in 24 hours, that might not be something that you can negotiate with a union. So that would be an exception. The other exception is the possibility of remote bargaining. Ordinarily, collective bargaining needs to occur in person, and any party who wants to do it in person has the right to demand that it occurs in person. It remains to be seen the extent to which employers or unions can demand either Zoom bargaining, phone bargaining, proceeding in writing rather than in person. So just keep that in mind to the extent you do have bargaining obligations coming up. Just real quickly going to cover at a very high level what's going on in Washington. I had the misfortune of preparing this slide last week, so of course all the information is woefully out of date. I looked this morning and saw that under the 538 polling average, their projection has President Biden or Vice President Biden currently up 10.4%. We've definitely seen movement in that direction since the first debate, as well as then President Trump's COVID diagnosis. Judge Amy Coney Barrett is currently in the middle of Senate confirmation hearings as we speak, notwithstanding the positive COVID tests for a couple of Republican senators. They've decided to go forward with that and are going forward with it. So it remains to be seen whether we get a vote prior to the election, but that's certainly the intention right now. And the COVID stimulus negotiations, they were dead, then they were alive, then they were dead again, then they were going to be alive, but after the election. Last I heard, just looking at it this morning, it sounds like there's some pressure on the Democratic side to accept the Treasury Secretary's most recent offer. So who knows? Basically, just kind of stay tuned, and we will be reporting on that as it occurs. Just want to talk again really briefly about a couple of recent Supreme Court decisions. With that, I'm going to hand it over to Jessica and Scott.
All right, hello. Thanks for that. It's always a little bit of a trick to get back on camera and unmuted. It's not exactly seamless, but we're doing what we can. So the Bostock versus Clayton County case before the Supreme Court was earlier this year, and I would bet a lot of folks on this webinar know that what this case held is that Title VII protects people against discrimination and harassment on the basis of sexual orientation and gender identity. That means that an employer cannot discriminate against an employee because they are, for example, transgender or gay or lesbian, queer, bisexual, plus. So this is, I think, pretty well understood, and it's a good practice to generally not discriminate against any employees on any ground. So I think that has been well sorted through over the past few months. I think what's more interesting about this case is a couple of things. One, as noted, it had a very uncommon split. So Gorsuch, for example, sided with the liberals. And as we're going in the throes of another Supreme Court nomination process, it's a good reminder that I don't think anybody can really predict what any judge is going to do on any specific issue. So that's a good reminder. Another reminder is that stereotypes matter. And another thing that the Bostock case tells us is that we can't discriminate against somebody because they don't fit our perception of what a person should be. This man is effeminate. This woman is masculine. Those types of stereotype busting, people that don't fit those molds, are now very clearly, under the Supreme Court jurisprudence, protected from discrimination on that ground. And then one more takeaway on this one, this is the one for the lawyers on the call. It clarified the causation standard applicable to many of these discrimination claims. Title VII is that federal law that prohibits discrimination and harassment and retaliation on a number of grounds. And most state laws have an analog where it just copycats all of the federal rules and jurisprudence. So for this one, the court clarified how this concept of but-for causation operates. And it clarifies that but-for causation means you would not have been, for example, fired, but for the discrimination, but for the complaint. That means that absent this thing, you would not have felt this consequence. And the court clarified that but for does not have to be the sole cause. It doesn't even have to be the primary cause. And it's a good primer on how but for causation works. And as long as this action would not have been taken but for this category, then an employee can prevail, even if the employer can show additional reasons for the action. So I think that's an important clarification that hasn't gotten a lot of ink in the press. Scott?
Yeah, so I'm gonna just quickly talk about the Our Lady of Guadalupe school decision. So this case involved, two school teachers who, who were terminated, and they raised, one of them was age discrimination, the other was disability discrimination against their employers. And what the Supreme Court did is they really expanded this doctrine of the ministerial exception. So under that exemption, that basically says, the religious school or institution gets to select who its ministers are, and we don't want to have courts, being involved in that, kind of religious decision by allowing, somebody to maintain a lawsuit, and then you'd have to reinstate somebody who's a minister. So it's just a whole area that courts have wanted to stay away from. And what this case did is it broadened it to, at least for, school teachers who teach math, reading, if, religion is something that they also teach, and the employer can make an argument that this is somebody who furthers what our religious mission is, then that's going to be, the court is going to defer to that and not second guess, what the is, as long as there's some, reasonable argument that they have that this teacher is involved in our religious instruction and our religious mission. And an interesting, part of that is that it was a 7-2 decision. So you had Justice Sotomayor and late Justice Ginsburg dissented, but that was, you had some of the liberal justices joining on to that opinion. So now I'll turn it over to Ryan on the pending cases. Ryan, your mic is muted.
Thank you, Scott. Just kind of an interesting takeaway is that even though we often expect these decisions to be 5-4 and the justices to fit with their pre-aligned ideologies, that's not always the case. And just to close out, a couple of pending cases that are currently before the Supreme Court under its current term. These are mostly really kind of inside baseball type cases, so I won't go into any detail. If you are involved in drug reimbursement under Medicare or a railroad employer, you'll want to follow these cases a little bit more closely. But it's not likely they'll have a lot of general applicability to the broader community, aside from the issue of ERISA preemption in the Rutledge case and the abilities of states to regulate things that are also covered by ERISA. There's also the Henry Schein case, which involves the extent to which an arbitrator can determine the arbitrator's own jurisdiction, or whether the judge gets to decide whether the arbitrator has jurisdiction over a particular case. This is not an employment or labor arbitration case, it's a commercial arbitration case, so it's not clear the extent to which it will apply to the employment and labor arbitration context, but obviously we'll be monitoring that and seeing what the decision says when it comes down. So after some interesting Supreme Court fireworks, I think folks are looking forward to maybe a little bit of a quieter year. With that, thank you so much for your time and attention, really appreciate it. And we're going to hand it off to Rachel Steely, Dan Kaplan, and Cameron Marafity, who will transition to talk about what does this all mean looking forward. Oh, I guess first we have a CLE announcement. The first CLE code, if you're seeking CLE credit today, is OL8TK. We'll leave this up here for a minute before advancing, but the CLE code, OL8TK. And with that, I will hand it off to Rachel, Dan, and Cam.
Good morning or afternoon to some of you as well. And thank you for that great presentation, guys. There is a lot going on. So now we're going to move along and talk about, now that we have seen what the rules are and what we're anticipating the rules to be, what does this all mean? How do we protect ourselves, and what are we going to do next? And in doing that, we are going to talk a little bit about policies. And there's all types of groups of policies. That's the first thing we're going to talk about. There's all types of groups of policies that we need to think about. And we're going to go through many of these today, and I'm going to talk about these for you. The first type, we're going to go through employees, non-employees. We're going to talk about the FFCRA and all the different issues that you had just discussed, what the law was previously. Now, as an introduction, my name is Rachel Steely. I am here in Houston, Texas. Jessica's on the other side of that wall over there. We're not even in the same room presenting for you. So there are a lot of policy variations that we see throughout the United States, just as Jessica talked about how a lot of the laws are different. And we're going to talk about what we think some normalcy can be given to the workforce throughout the United States with the policies. We will start first with our employees. No, we won't. We're first going to start with a joke. Okay, we've got our one side of the brain working on this very technical issue of COVID employment area. But first, I'm going to give you a joke. Now, did you hear the joke about COVID-19? Never mind. I don't want to spread it around. Okay, so now that I've got your attention, let's move on to employee policies. So there was some information earlier today about teleworking as well as timekeeping, but I want to expand upon that a little bit in our presentation today as well. And with the teleworking policies, the discussion about what people are doing with regard to the policies of teleworking and the communications. The first thing, if you're having individuals who are teleworking, which all of us are, right, then you need to put together some consent forms for teleworking and policies regarding these consent forms. There are different issues that you have to look at, such as how many hours or what day a week that they may be teleworking, the length of time, and the need. And just prior to this, they discussed the different states and the different cities that may have different rules and laws on teleworking. And that's important to take into account when you're putting together your policy and your consent forms as well. Now, timekeeping. Remember the good old days when people would log on to their computer or take their time card and log it in, and it was so easy to keep track of time? Well, we know that's not the case anymore. So when you're having teleworking individuals, timekeeping is crucial, and having a policy on how those employees keep their time is really important as well. And what do I mean by that? So there are different types of policies and different types of ways employers are looking at teleworking. There are some employers that tell employees not to log on to their computers until they've been contacted for work. There are some mechanisms and policies that say that some non-exempt employees are not allowed to log on to their company emails or onto their computers after a certain point in time. And if this is the rule that your company is going to have, it needs to be in a policy, because like all other wage and hour policies, when we're looking at overtime, what the wage and hour wants you to do is apply your policy. And if you're not applying your policy consistently, then you need to discipline people for violating that policy,
Yes.
or you have to pay the
You
overtime
mean
that's associated.
Medication. Excellent.
All right, so I think we have one person who has their mic on. Maybe get that turned off. All right, so another thing we have to think about with some of these policies and your teleworking and returning to work is COVID testing. And I'll go to travel policies in just a bit. But I know that Jessica had talked quite a bit about COVID testing earlier and about what some of those rules are. Now, we have people across the board that wouldn't put into place some mandatory type of testing. And mandatory type of testing is not per se a violation, right? Unless it's an antibody test. But you really need to think about how you're using it, because the CDC just recently came out and said that they are not recommending negative COVID tests for people to come back to work. They are recommending symptomatic issues is the way that the companies ought to look at who is coming into the workforce. So your policies need to reflect these type of COVID issues. So you also have issues of what if an employee refuses to take the test? What is your policy going to say about refusal on a test? Are they permitted a leave of absence? Or is the testing going to be something that is not mandatory for certain groups? And think about also some of the ramifications. For instance, the city just north of us, Dallas, Texas, has a local ordinance, and they tell employers that they are not allowed to have an employee have a negative test after they've had COVID to come back to work. So you need to, again, check your state and local ordinance as to what your policy should say about any type of COVID testing. COVID reporting. Now we know the EEOC said that you can have COVID reporting with healthcare officials. But one of the most important things is with COVID reporting is that you need to make sure you have consent of the individuals. And this is where your policy or documentation is very important. So when you're looking at employees, the best thing you can really have is a protocol for having employees come back to work. And part of that protocol is basically a piece of paper that you can give your employees that says, welcome back to work. We're glad to have you. And there are some other things you need to know about returning to work. Number one, that they're assuming the risk for coming back to work. Number two, that they are also agreeing that you can use information regarding whether or not they are testing positive for COVID with not only health officials, but with your insurance companies, with other employees, and with management. You need to have the consent from these employees, and it's an easy thing to get if you put together a comprehensive return to work protocol and policy for your employees. Now, why else is that comprehensive policy so important? Well, if you've seen the federal Safe to Work Act that is being proposed by the federal government, it specifically calls for companies to put together policies for their employees on how to return to work and on safe work environments. So a couple of things under the Safe to Work Act, which actually is called Safeguarding America's Frontline Employees to Offer Work Opportunities Required to Kickstart the Economies Act. SAFE Act, right? Well, some things to know about that. It says there that employers must take reasonable efforts in order to protect their employees. And what is one of those reasonable efforts? Is to have policies in place. So if you need something to take back to people that you're working with, or something to help push your policies forward, give them a copy of the CARE Act, of the Safe to Work Act, because it specifically says this is what the proposed new federal law is going to retire. Another thing, and this is what was really surprising to me, is what this act does is it provides basically no liability for employers for any type of injury due to the employer's negligence. So those injuries occur from December 2019, and the protection lasts through the end of 2020. Now, that also tells me a little bit about what they're thinking about in Washington, about the length of time this is going to last. So put your policies in place, because that will help mainly prevent you from future liability against claims, and also will give your employees guidance on what they need to do next. What about non-employees that are coming into the office? Well, non-employees also have protections, and they should be protected as well. Number one, you need to provide your vendors and your customers with information as far as the efforts that you've taken, but more importantly, a policy that they are now allowed to enter into your work area or to come into the premises unless they are symptom-free. So again, just like you have a policy for your individuals at work, for your employees, you can put something into place, again, a piece of paper they sign off on, or you may have, if they come in and sign in electronically, or any other method that they can sign off that one, that they are symptom-free, and that two, they're assuming the risk for coming onto your premises. And that's important because COVID is spreading so quickly. You know, they say love has no borders. Well, neither does COVID. And the mere fact that we see people now starting to move around quite a bit more, it's very hard to pinpoint where COVID may have come from. So that is why it's important to get these signed policies, get these signed acknowledgements for people coming into your workforce. You also need to have a policy for your company so that they know, for your employees know, that this is also required of people coming in. If you give these individuals advance notice, then they may not be taken aback when they come in. And let's face it, this is pretty much common, the common knowledge or the common way that we're working right now. You know, when you go into a place, you should have a face mask. So having a policy and having an acknowledgement requiring someone to have a face mask, that's not going to be unusual. But it's also going to protect your company if you do put it in writing. Next is the FFCRA. So a little bit about the FFCRA and policies. So the FFCRA only applies to companies under 500 employees, but it is good policy in order to think about these types of leaves. And you have the EFMLA, which is basically the family and medical leave for COVID, and the emergency paid sick leave. Now, we just had some new regulations that came out last month, and the big thing about the new regulations is that in policies that you have for your individuals, you can not require them under the Emergency Paid Sick Leave Act to give advance notice in order to have leave under this law. In fact, under both the EFMLA and the Emergency Paid Sick Leave, your policy should say that they need to give work as soon as practical. So basically, practically speaking, what does that mean? When you have telework or intermittent leave policies, you have something these employees are signing off on. And if they are needing to telework or they are needing to take off work and to be paid, right, then they need to give you notice as soon as practical. And that should be part of these consent forms. In addition, there is a little caveat between the EFMLA and the Emergency Paid Sick Leave. As a practical matter, we suggest all policies say to give notice as soon as practical. But just so you know, under the EFMLA, you can require prior notice if your employee knows ahead of time that they're going to be out, much like we do under the FMLA. And let me give you an example. So for example, you have an employee who comes to work on Monday and says, I have a child whose school has just notified us that they are going to be closed on Thursday and Friday, and I have to stay home Thursday and Friday. Well, that employee needs to give you notice early because they have notice of it early. However, if you have an employee that comes to work, they're at work and they get a phone call from their school and they say, gee, we're having to shut down because we've had some positive COVID tests, and they have to run and get their children, they can't give you neatly a notice ahead of time. And that's an example of notice as soon as practical. All right, so I am now going to turn this over to my partner, Dan Kaplan.
Thanks, Rach.
All right.
I appreciate it. Can you hear me okay?
We can hear you now.
Okay, great. My name's Dan Kaplan. I'm a partner in our Madison, Wisconsin office. I co-chair the National Labor and Employment Practice, as does Rachel with us from our Houston office. We've talked a lot in this webinar already about COVID, and that's not a surprise because that's pretty much dominating the forefront for all employers today. I'm going to focus in particular on one aspect of our new normal that has taken place as a result of the coronavirus. I'm going to focus on what you must do to be prepared to address remote work issues. As you've heard already, a number of state orders, as well as some national orders or guidance from the CDC, have spoken to and address trying to get everybody to work from home. One of the best ways to effectuate a ratification of COVID or to control the spread is to limit the amount of interaction by and between persons, whether that's through social distancing or working from home. As Scott Allen noted, there are a ton of states that had implemented immediately upon the occurrence of COVID, state orders that required or mandated working from home. Pennsylvania, as an example, still has a required work from home mandate for all non-essential businesses and operations. As this has occurred, more and more employees have been working from home, which has led to more and more issues for all of you in addressing how do you control the work from home issues? How do you keep productivity up? How do you address other concerns? So, one of the first things that I want to remind all of us is that simply sending somebody home to work with a laptop is not necessarily the easiest thing to do or the end of the resources that you should make available for your employees to work from home. Yes, everybody needs to have the internet and needs to have laptops or desktops to work from home. That's fairly obvious. But not everybody has internet access. So as Rachel was talking about policies to have been implemented for working from home, you should also have a list of those resources that you can make sure that your employees have, or if they don't have, how to get them for them. So for example, internet access, laptops, telephone communication services. Do they have a good chair or workspace at home for them to utilize? Is it set off and apart from their children if the children are studying from home? Will it interfere with their operations on your behalf? Do you want to have employees, when they're conducting video conferences, use a common thematic background like you're seeing for a lot of us today, the Foley logo, the Foley office building outside? Things like that you have to give some thought to as we continue to operate in a remote environment. Does OSHA apply? Scott spent a lot of time talking about OSHA and how to address it, particularly as it relates to a work environment or a factory environment. OSHA has published a memorandum that says we are not going to conduct inspections at any telework location. We may inquire of you and with respect to your employees if they have resources for their telework environments and that you have at least spoken with them about those resources. But we're not going to inspect people's homes. That's not what they're going to go out and do. So you really don't have to worry about OSHA at a homework environment. The biggest issue that you have to work with or deal with is the issue that Jessica spoke about, and a little bit of the issue that Rachel has spoken about, and that is wage and hour concerns. Controlling the recordation of hours worked for our non-exempt employees from home is the single largest challenge that our clients have faced during this pandemic. Rachel mentioned, and I think it's a great idea, that a number of employers have gone to making remote access limited until they have their time of work day start. So for example, if you have the technological wherewithal to prevent an employee from gaining access to your work platforms and work resources on the laptop until they clock in, until their shift begins, that's a good switch to flip. Same with flipping it off. We are seeing already a number of litigation cases started with wage and hour class and collective action claims. The principal claim is working off the clock. That is, my employees or your employees have started working at 6 a.m. when they got up, they do some work, and then they work the entire day until 6 at night. If you don't have either policies or technological resources to actually capture the time worked, you're going to be facing these kinds of claims. And don't forget, under the regulations associated with the Fair Labor Standards Act, as well as most state wage and hour laws, it is the employer's obligation to track the time work, to maintain these hours worked by their employees. So if you're not able to do that, and if you don't have the policies that Rachel was commenting on in place to do that, you are going to get hit with many claims in this area. Many of our states have implemented or opened up their businesses and their restaurants and other activities and said, you can go back to work. Some states opened up a little early and we saw an increase in the number of infections and their spread. But at the same time, it's this balancing act, right? States are struggling with, do we close businesses, mandate a close of business so that we can control the spread and potentially damage the small business person? Or do we open it up, allow people to come back to work and try and control the spread through policies and other resources? Not unexpectedly, as businesses opened up, employers started facing the employee pushback about coming to work. So the question becomes, if you are an employee or if you have employees and they don't want to come back to work because they're scared, nervous, concerned about exposure, maybe they have relatives in the same household with immune systems that are at issue, or they themselves have a challenged immune system, and so they are more likely to be to suffer some harm if they contract COVID. So you're getting all this pushback. So what can you do? Do you have to allow an employee to say, hey, you know what? I'm nervous. I'm not coming back in the workplace. I've been working just fine from home, and I think I'll continue working just fine from home. Well, as Jessica said, this is the $1 million question, and the typical lawyer answer is, it depends, right? The EEOC has spent time on this issue and has essentially said, listen, we're going to control or give you, employer, the controls to deal in a progressive manner, whether or not you can force your employees back to work. And just the fact that you have had remote working or teleworking during this pandemic does not mean that that is the most effective means for operating your business. And just because you permitted teleworking and remote working in this pandemic up to now does not mean that you have to continue to allow remote working and teleworking. We're going to get into that specific issue a little bit more in a few moments, but there is one critical area where the it depends issue requires further analysis, and that is where the question involves a disability. So the Americans with Disabilities Act and various state laws that address disability say that you have an obligation to engage in the interactive process with your employees and obligation to reasonably accommodate any employee's disability through a reasonable work accommodation, so long as it does not cause an undue hardship. If you have a compromised immune system or you have an employee with a compromised immune system, that may constitute a disability. If going into the workplace creates an increased risk of harm to that individual, you may have to engage in the interactive process with that employee in order to explore, are there reasonable accommodations that you can provide to allow that employee to perform their essential functions. And bear in mind, the only accommodation is not necessarily just more telework. There are a plethora of accommodations that you could allow your employees or afford to your employees that will get them back in the workplace, even if they have compromised immunities. Examples: mandatory mask wearing, respirator use. Bear in mind that if you are going to provide a respirator to an employee, now you have to implement an OSHA compliant respirator program. But having an OSHA compliant respirator program is typically not that difficult. There are hoops you have to jump through, but you can do it. And once you do it, you can provide a respirator, whether that be an N95 or some other form of respirator, to an employee with a challenged or compromised immune system to get them back into the workplace. Maybe you stagger shifts as an accommodation or the work hours for that employee to get them back into the workplace. Provide face shields in addition to a face mask. Provide wipes, hand sanitizers, all of the things that we all know you have to do as an employer now in this COVID environment can all serve as reasonable accommodations that will allow you to get your employees back into the workplace and not limit you to only telework situations. We're going to deal a little bit more with some of the leaves, because leave can be a reasonable accommodation as well, and what pay is required under some state and national rules and laws for leaves. But before we get to that, I'm going to turn it over to my colleague and partner, Cam Rafferty from our LA office, and he's going to talk about some of the traditional labor issues that you might be required to address in this environment. Cam, I'm flipping it to you.
Great. Hi, everyone. So I'm going to talk about some of the labor issues that could apply here. But just keep in mind that while most of what I'm going to talk about relates to those with a unionized workforce, there are some things that I'm going to address that pertain to everybody, even if you are not a unionized workforce. First of all, for those that have a unionized workforce, generally, I'm sure you are aware, generally most material changes to the terms and conditions of employment have to be bargained for with the union. There is an exception to that, though, for any unforeseen major emergency that has impact on the employer. So for instance, related to the pandemic, those that had to immediately lay off a bunch of their workers or to shut down their facility had a potential exception available to them to avoid bargaining. Some of the laws that have come out regarding this haven't pertained to the pandemic specifically, but relates to prior emergencies like a hurricane that resulted in an evacuation of the city, or a hurricane that resulted in a power outage that resulted in the employer having to shut down, or even things like 9/11. So emergencies have allowed an employer to avoid bargaining and implement a change and then deal with the impact of the bargaining at a later date once the emergency has passed. There's also even other emergency issues that an employer could rely upon that are not related to like a general wide-ranging emergency like a pandemic or a hurricane, but even like a loss of a line of credit that was unexpected, or a major supply shortage in the type of material needed for producing a product. Anything like that could give an employer a means of avoiding bargaining until that emergency event has passed. So there's an argument, though, that right now, since the pandemic has been around since March, most employers have been aware of these issues, and so any change now may not be an emergency anymore. So it's possible that that exigency related to the emergency is no longer applicable. So just keep in mind, if you're going to make a change, most likely you're going to have to bargain with the union at this point, unless it's something new that is being implemented that was unexpected. Either way, just be mindful of the fact that even if you can avoid bargaining regarding the decision regarding that change that you plan to make, you will still have to eventually bargain over the effects of that change. So for instance, if you laid off a bunch of workers, maybe you were able to avoid bargaining on that initial layoff, but you will eventually have to bargain over the effect of that layoff, such as potential benefits for those that are laid off, healthcare benefits and things like that, and how that would apply. So now I'd like to talk about other legal issues that are likely to apply for under the NLRA, the National Labor Relations Act. Generally speaking, the pandemic has not absolved any requirements of the NLRA, except for that bargaining issue that I just talked about. So employers have to be mindful of the fact that if an employee, whether it's a unionized workforce or not, decides to walk off the job with his or her coworkers because of unsafe working conditions, or if they decide to protest because of unsafe, any other reason regarding working conditions in general, you can't take action against those individuals. It could be considered retaliatory. So even if you're not a unionized workforce, this is a law that would still apply. The reason for this law is it's a considered protected concerted activity under Section 7 of the NLRA. So if there's an action that affects two or more individuals, that would be considered protected activity, and you can't retaliate against those individuals for taking that action. As Ryan also mentioned, you need to be mindful of layoffs and reinstatements. So if you lay off a bunch of workers and you end up laying off, or you lay off only the unionized workers, that could be an issue potentially for disparate impact and retaliation against the union workers. Same thing goes with reinstatements. If you're reinstating all the non-union workers, but keep continuing to lay off all the unionized workers, then you still have a potential issue. Ryan also mentioned that the pandemic doesn't also excuse your duties to process any grievances and to provide information to the union upon any request. All of that can be done virtually potentially these days, so you can't rely on the fact that there's a pandemic to necessarily avoid those obligations. So for those that are not unionized, we want you to be aware that there is a potential uptick in union organizing activity that could occur as a result of the pandemic. Although generally speaking, the last 6 months or so, we've seen a reduction in union organizing because of the shelter-in-place orders. But because of the effects of the pandemic, we could see that there could be a potential uptick coming up, regardless of who wins the election. Usually, things like this makes employees feel less secure in their job. They might see that there's an increased risk of future layoffs or furloughs. Or they might believe that the safety in the workplace is not sufficient, and they might turn to a third party like a union to address those issues. So what could you do to prepare for this potential surge? First of all, be mindful of the industry you're in. I mean, those industries that have been heavily impacted by the pandemic, including hospitality, healthcare, logistics, food service workers, those industries are more likely to be subject to potential union organizing. You should also be mindful of the fact that most likely employers or employees tend to not turn to a third party like a union if they feel like they have sufficient resources within the company to address their concerns. So if you have a good HR personnel, if you have good management, if you have good policies, those employees could feel more comfortable to talk to those individuals. And if they feel like that, if those individuals are listening to them and trying to address any legitimate concerns, they could see that to be a better option than going to a third party like a union to come in. Similarly, also like good HR practices and management could result in better ability by those individuals to address any workplace concerns or complaints that arise. So if you investigate any concerns and address them right away, employees are more likely to feel comfortable and avoid the union. Lastly, it's best for management to have a positive relationship with their employees. The relationship is more likely to be positive if employees believe that they're being treated fairly by their supervisors and there isn't kind of any favoritism going on when it comes to the way shifts are handed out or the way discipline is handed out. Management is doing the right thing and complying with policies and doing it in a fair way, they're more likely to avoid going to a union. So now I'm going to turn it back to Rachel and Dan to talk more about leaves and PTOs. So Rachel, I'll have you start again. Must an employer continue to allow work from home under certain circumstances?
So Cam, this is one of the things that Dan brought up when we've been talking about is that the EEOC has given us some guidance on this, that a work from home or teleworking is not necessarily, is not an accommodation. Oh, look at that. Look how good you are. You go straight to the EEOC guidance. There you go. The EEOC tells us that's not necessarily what you need to do, but again, they throw us back into this interactive process if a person is considered to be disabled. The other issue we have with the teleworking, and quite frankly, I think this is one of the biggest issues that we are seeing in the workforce in states that are not mandating the type of telework, is the people who are very much on one side or the other issue about whether or not people ought to be coming back to work and why. So remember, with regard to teleworking and with some of the other leave, you also need to think about the FFCRA if you're under 500 employees. I know I had one incident that when we opened back up here in Texas to a large group, a client said, we basically told them, you need to come in unless you have some type of health issue or you're going to be fired. Now, wait a minute. Those type of bright lines are the type of bright lines that are going to get people in trouble. When you're looking at why people need to come back to work, You need to make sure that you're articulating why they need to come back to work. That's in line with what you already have in written documentation. Because if your documentation says one thing, such as your essential functions in your job descriptions, and then what you're telling your employees, then that can be troublesome as well. So and then the other issue is productivity. If your company's truly being productive, and you have people who need to stay home for childcare or other issues as well, that is an issue that also needs to be addressed. But the EEOC at least is giving us that flexibility in order to for the companies to make those decisions. But making sure you're looking at what you already have in writing to be consistent as to what your current or your new policy and procedure is going to be important. On to the next one. All right.
Yes, let's go on to Dan. So what leave laws should employers be aware of?
Well, as Rachel mentioned, and as has been mentioned previously, we have to deal with the intersection of the FFCRA and the ADA interaction process. As everybody's aware, perhaps a modicum of leave can be a reasonable accommodation in various circumstances. So you can't simply write off an employee who says, I can't come back to work, when you start to implement a return for all employees back to work. This is a situation everybody's going to have to deal with, and you're going to have to take the time to engage in the interactive process. It's that simple. It doesn't have to be challenging. It doesn't have to be difficult, but you have to engage in that interactive process. Now, with the FFCRA, you also have to do what you would normally do with FMLA. Track it, right? Make sure that your employees complete an application for leave. As we learned recently, the Department of Labor cannot force a leave to be denied if the application for leave is not turned in a period before the leave is necessary, but you still get to require an application for FFCRA leave, whether it be paid sick leave or whether it be emergency family leave. So you're going to have to deal with those things. And those are the two principal leave laws that you need to address on a national scale. But there are various state laws that you also cannot forget about. So for example, in California, in your backyard camp, we see legislation that has come down with mandatory paid COVID leave in certain circumstances. So you're going to have to make sure that you're checking the box on what state laws may have application, as well as the ADA and the FFCRA.
Great. Anything else that employers can do to make employees feel more comfortable besides just provide leave?
Yeah, absolutely. And we talked a little bit about this earlier in my presentation, that leave is not the only possible accommodation, right? You can utilize masks, face shields, gloves. Maybe you give people smocks, right? And you have laundry service. Don't forget to think outside the box, right? Try to use shifts and bringing people into the workplace at different times so they don't have to congregate at an elevator to get up to their office. Have them leave at different times so they don't have to share elevators when they're leaving the office. Most employers had at one time or another tried to get away from plasticware in their workplace in order to be beneficial to the environment and introduced hard silverware or plates. Maybe this is the time when you're going to go back to the plasticware right now. So you don't have employees sharing tools or sharing resources. Ensure that every employee has their own keyboard. If you have an employee that is sharing a keyboard with another, make a policy, have a policy in place that requires the last person to utilize that keyboard to spray it down, disinfect it prior to leaving the workstation or the work area that they're using that keyboard at. Have policies in place, know who you're going to call for the deep clean. whenever you have an actual COVID case or individual with COVID-19 in the workplace, you want to segregate that work area. If you can allow it to sit for 24 hours, that's the best protocol according to the CDC, and then conduct your deep cleanse. If you don't have the luxury of a 24-hour period, get right to the deep cleanse, but know who you're calling to conduct that deep cleanse. Those are the things that I think I would focus upon.
Okay, and I'll have you close it out, Dan, with just a last slide about what is the cost associated with these leaves?
It's a great point, and I think a lot of employers are seeing costs impact their bottom line from their teleworking. I think at the start of COVID-19 and the pandemic in March and April, we saw productivity was actually increased. As time has gone along, people have really kind of worn out, right, from working from home, and productivity has decreased, and that's a cost in and of itself. Remember though, if you have to have an employee at home, you can encourage them to stay home by providing them with FFCRA benefits, because those are paid benefits, and that doesn't hit your bottom line, right? Any amounts paid to employees under the FFCRA are dollar for dollar deductions from your payroll taxes. So you gotta maintain records for the reason that the employee's home and the reason that you're paying out those FFCRA dollars. Just in case the Treasury or IRS were to audit you, you have that record. But that's not going to be a bottom hit to your bottom line. And I wanted to touch on two other things. One thing is that a lot of clients ask, hey, do I have to provide hazard pay? There's no such thing as a national hazard pay. And I would strongly counsel all my clients never use the phraseology hazard pay, right? It implies that there's something terrible about working in that environment, that it's a hazard. If you want to give employees a bonus for working through these challenging times, that's fine, right? We talked about a little bit of the bonus rules and the things that impact that from Jessica's discussion, but don't call it hazard pay. And then, as I mentioned a moment ago, be aware of your state laws that do require paid leave, or that are being implemented now requiring paid leave in your states, like in California, like in some other states as well.
Thank you, everyone. And now we'll turn it over to Larry.
Hi, everyone. I'm Larry Perlman here in our Miami office. Before the break and that all-important CLE code, the last segment was titled, "What does this all mean?" Well, this segment is titled, "What can this all mean?" And what that means, at least for the next 45 minutes, is that along with Krista Cabrera in San Diego and Mark Neuberger here in Miami, along with me, we're going to take out our crystal ball and we're going to talk about what we predict for 2021 and beyond as folks continue to go back to the workplace. And I just need to figure out how to, in 2020, advance the slides. Okay, apologies for that. In any event, I'm taking the lead to discuss social justice in the workplace. And first, what I'm not going to do is give a lengthy dissertation on social justice concerns in 15 minutes. That would be absurd, it would be impossible, it would be an unbelievable insult to all the work much more qualified folks do regarding important social justice issues. Instead, I'm going to speak through my experience as an employment lawyer as to some of the more common concerns we anticipate seeing in the months and years to come. Second, isn't the title of this morning's presentation Working Through the Pandemic? So Perlman, why are you talking about social justice issues in the middle of all this? Well, remember, we're talking about returning to the workplace and looking ahead to our new normal. And as folks are continuing to come back to work, all the issues that are really important to them are going to come back to work with them as well. And if they're anything like me, they haven't been around colleagues for months. They're going to be very anxious to express themselves and what's important to them, and that's going to be including via how they dress and what they wear. What is important to Americans and our employees? Here are the results of just one recent poll. It's a Kaiser Family Foundation national poll of registered voters in September. In the midst of our economic upheaval, in the midst of the life-altering pandemic that we've been discussing all morning, A full 30% of respondents listed either criminal justice or race relations as the #1 important issue to them for the upcoming election. That's a full 30% for whom these issues are the #1 concern, and you can be sure it's the #2 or 3 concern for many folks as well. So it would be easy as an employer to say, that's fantastic, but here at Willie's Widgets, we don't permit any distractions. We don't permit political expression, and we certainly don't let folks wear any type of logos in their clothing. We're all about making widgets, not about making political statements. I'm going to take an important aside here for a moment. No insignia and no logo dress code policies are quite common because what they do is they essentially let you prohibit union paraphernalia. And I'm going to oversimplify it, but when you permit some, but not other types of insignias or logos in the workplace other than the company's logo, you generally lose the right to prohibit union logos. And that's one of the reasons, among others, that you'll often see these neutral dress codes with no logos, no insignias. But in any event, the we just make widgets world is no longer the world we live in. If 2020 taught us one thing, it is that employers are going to have to make choices, or as I'm trying to express by pictures, it's going to be harder and harder to be Switzerland or that ostrich with your head in the sand. What do I mean by making choices? Here's one example. Back in June, a group of Whole Foods employees in Cambridge, Massachusetts wanted to wear Black Lives Matter pins and masks. This was important. This was right after the death of George Floyd. Those employees went and asked their supervisor, who basically said, sorry, no pins. That's our dress code. We support the movement, but we do so in other ways. What happened then was the social media-verse did its thing in its own ways. The employees at issue tweeted their discontent. That's above in small print. Within 2 days, we had the CNN business headline below. Shortly thereafter, within weeks and many other major news outlet headlines, Title VII class action suit was filed alleging discrimination on the basis of race. And while the company has moved to dismiss because the plaintiffs didn't go to the EEOC first and exhaust their administrative remedies, the fact is, if you just go to Google and type in Whole Foods, Black Lives Matter, masks, pins, you can see the publicity effect of all this, and it's not a comfortable or positive publicity effect. Here's another example of the same concept. Starbucks, up until recently, had a neutral, no shirts and pins with any types of logos or insignia policy. There was much backlash for the reason that there's been backlash, that we saw the backlash against Whole Foods and so much other backlash. And the upshot is, if you go to your local Starbucks now, you're likely to see baristas wearing Black Lives Matter pins and shirts. In fact, the coffee retailer has made almost 250,000 pieces of Black Lives Matter apparel available for its employees to wear. What happened was Starbucks made a decision. The company decided not to be neutral in its dress code, even though doing so could have other significant consequences. It could have significant labor consequences. It could have consequences as to the ability to prohibit other types of logos or insignia, and it could have other PR consequences. But once again, nothing's easy, and it certainly goes both ways. Earlier in the summer, the Twitter sphere was in a frenzy over an alleged Goodyear Tires policy of permitting LGBTQ pride and Black Lives Matter shirts, etc., but not permitting Make America Great Again logos or Blue Lives Matter gear. Goodyear, in fact, denied having such a policy in place, but that was the perception, and some employees tweeted clips of what they said was a presentation during which an HR manager explicitly put up on the slide such a policy. Many rationally defended the notion, explaining that expressing belief in one's humanity and inherent value is not a political statement, and you could prohibit political statements without prohibiting statements as to whether Black Lives Matter. Nonetheless, a certain very prolific tweeter who lives in Washington, D.C., took issue with this Twitter storm over the possible Goodyear policy. Here you go, it's right up in front of us. And the upshot was, a couple of days later, Goodyear eased up its formal policies and is permitting a variety of logos and insignias. Ultimately, it's going to be very difficult to go on with the status quo, especially if you have a policy of neutrality in terms of what employees wear and how they express themselves. What we're seeing from these examples is every move you make or you don't make with respect to what employees wear or not is going to require a deep analysis of your organization's values, the PR effect, and the legal effect. And doing nothing may be seen, and often will be seen, as taking an action in and of itself. So from a legal and exposure point of view, how do we at least begin to think about all this? Because it certainly does seem that impossible choice of, well, negative effects if I do something and negative effects if I don't do something. Here are just a few pointers. First, a lot depends on whether you're a public or government sector employer or a private sector employer. If you're a public employer, remember, your employees have typically state and certainly federal free speech rights, and there's much less you can do to limit free expression in the workplace. You can have limits, but the limits are going to be much more restricted than for a private employer. Second, it is really difficult to enforce a dress code that you don't have. And what I mean is, you need to make sure that your managers and supervisors who are on the front lines know what the actual rules are as to what employees can and can't wear. In fact, the best guess is that this is some version of what happened with Goodyear. Nobody knows for sure, but it appears it may be that one person in HR listed some do's and don'ts during a presentation that simply did not reflect the overall corporate approach or do so accurately. In other words, managers must be very careful and not just reflexively decide that something is, quote, inflammatory or inappropriate, or that something's permitted or not permitted. You certainly can't do so without looking at the policy or looking to see if such a policy exists. Because what happens is, suddenly you're disciplining one group in one store or office and factory, but in the other store or office or factory, same employer, you're not disciplining the same group or a different group. That's a discrimination claim, whether it be under Title VII or ADA or one of the other alphabet soup of laws that we deal with waiting to happen. It's also a Twitter and social media nightmare waiting to happen as well if you have inconsistency. Or what if you don't know about the policy? You don't have an established policy. Managers aren't aware of how you're approaching employees wearing different logos and gear, and you have policy of not letting union workers wear pins, and you've been in the midst of an organizing campaign. Your managers, however, have no or little idea about this, and they are not enforcing policies or even know we have a policy about logos that they believe are just and right and that employees should be able to wear. Unfortunately, that could be an unfair labor practice charge waiting to happen. Additionally, it's going to be important to remember that beyond federal law, the states you're operating in may have their own different restrictions. Remember what I said just a few moments ago about public sector employers and how public sector employees have much more in terms of rights regarding free speech as opposed to private sector employees? Well, if you're in Connecticut, that state basically protects First Amendment activity for all employees, even those of private sector entities. And political affiliation itself is also a protected category to varying degrees in a number of states, including California, Colorado, Louisiana, New York, and others. And what that means is, even when you're enforcing a policy over expression, you have to be sure in those locations that you're not permitting some kind of expression because you prefer the political activity of one employee or groups of employees over another. Here I apologize, just a few more tips are, I have to apologize because I am not a good driver of slides. In any event, a few more tips. As we know, things sometimes get very heated. That does not come as a surprise to anyone. That's the world we live in. These are issues of deep and personal importance to many, many employees. And employees, when discussing such issues, don't like how others treat them. And frankly, some employees all too often mistreat other employees when discussing deeply personal issues. No matter what protections there are or may be for right to wear certain logos, for right to political speech, there's never an excuse to harass employees. And that's something that companies should always keep in mind in terms of evaluating actions that may be couched under the guise of political activity or the like. The trick is how to handle things when the political expression itself is seen as harassment. So for example, someone may say, well, for a certain candidate, I take as a personal insult because that candidate or candidates believe in ideas or concepts that are anathema to who I am and what I am. There's going to be a real need to ferret out what exactly is said, how things are said, and discerning whether or not someone is indeed harassing a coworker or others, or is towing that line of acceptable speech in the workplace. These are battles to be played out, and they're being played out largely in the social media front. And one important concept is, if you don't have social media policies, you really should. It is extremely important to have clear prohibitions, including about what employees can and can't do in terms of advertising their affiliations with your entity, right? The last thing you want is an employee with extremely, passionate or heated or controversial views who also has the logo of the employer right there on their Twitter profile or their Facebook profile. And suddenly the whole world, something goes viral or less than viral, the whole world is seeing your company's logo being associated with that employee's activity online. So that's just one example of why it's to have clear prohibitions and limits as to what employees can and can't do in terms of affiliation with you when making their statements. And of course, it's incredibly important to, when you enforce your policies, be they social media, be they workplace dress codes, to do so in a consistent manner, taking into account all the laws that we always talk about, right? Title VII, the ADEA, the ADA, and ensuring that even when there's the ability to prohibit certain types of dress or to prohibit certain types of expression, you are not being disparate in terms of who and what groups of employees you are permitting or prohibiting expression. Finally, and I'll applaud myself for forwarding the slide correctly, I want to pay a little attention to something straight from the Department of Unintended Consequences. And here's the situation. In the wake of George Floyd's death, many companies, many entities rushed to send a message to their employees. It was a message of, we hear you, we're with you, and we're going to listen to you, and we're going to be introspective. Now, at least from my point of view, those are all objectively extremely laudable goals. Sadly, if history is any guide, there's a good chance that we'll have another similar incident that prompts employers to send out their company-wide messages to employees. What I put on this slide is sort of an amalgam of different letters that were publicly available, and I sorted them all through together, and here's what we have. Right? I'll read it out loud. Recent deaths of George Floyd, Ahmaud Arbery, and Breonna Taylor add to the unconscionable list of Black Americans who have lost their lives based on the color of their skin. We here at Willie's Widgets join those other Americans who recognize that this is a tragic story told in America all too often. And we must ask ourselves, what can we do to be better? We as a society, we as individuals, we at Willie's Widgets. This is standard language. Again, I took this from a variety of letters that are publicly available. We have all seen it. It is not problematic language, but it sends what I believe is an objectively good message. But in the zeal to do the right thing and send a good and positive message to our employees, we can make admissions or promises inadvertently that have a legal effect. For example, first paragraph going on, here at Willie's Widgets, we've asked the difficult questions and taken a hard look inward, and we know that we haven't done as well as we should have. For example, we looked at our upper echelons of management and noted that when it comes to diversity, our record with executives is abysmal. Our record with executives is abysmal. That may be true, and it may certainly be very refreshing to many, many people to see corporate America admit that there are significant challenges and issues. However, if you're defending a discrimination lawsuit brought by an individual who contends that he or she wasn't because of their race and sex, That statement of abysmalness, that's what's called a party admission in most courts in which we litigate. And you can be sure that our records with executives is abysmal, quote, will be up in some sort of big blow up for the jury to look at, throughout many important parts of the trial. And it can get even more concerning. Look at the next sentence in the hypothetical letter. Over the past 5 years, 96% of our executive level promotions have been white males. This is wrong. We must do better. We have to do better. We will do better. Again, this is wrong. That's likely true. We must do better. Likely true. But it's a problem to say this so explicitly when you're facing a real or potential claim that's alleging exactly the same thing. Plaintiff says, what was done to me is wrong. The company should have done better. Again, there's that admission right there. Seem to have lost the slides, and I think through no fault of my own this time. I'm just going to read off because there's not much coming, and hopefully the slides will be in order for Krista when she speaks. The next paragraph is, we will do better. And again, that said, from now on, we are committed to take steps such that by first quarter 2022, 30% of our C-suite promotions will be women and 30% will be people of color. Well, now you're on the record as admitting that a certain goal is reasonable, which is fine unless you fail to achieve that goal by the first quarter of 2022. And future claims will take note. Moreover, what I just read is looking very much like a quota. 30% of our C-suite promotions will be women, 30% will be people of color. That is looking like a quota, which segues right into the topic that our partner Krista Cabrera is going to explore in our next segment, which is on diversity and inclusion. In sum, it is a good idea. It is a laudable idea to provide messages of understanding, empathy, and self-reflection. But in doing so, I urge you to do so in a way that is mindful and cognizant of your legal obligations, potential legal exposure, and when you're sending out the messages, to do so in close coordination with legal, HR, public relations, and your other resources to ensure that your best intentions don't lead to harmful consequences for your business. With that, I'm going to turn it over to Krista, who's going to speak about diversity and inclusion as we look forward.
Wrong again, Larry. It's Mark Neuberger who's going to be taking the mic next.
Okay, well, thank you, Mark Neuberger.
Thank you. I'm Mark Neuberger from the Miami office. And Larry, don't hang up. So something that has come up in my own practice, and I think before I get into my slides, if you're going to take an approach of neutrality, or you're going to take a certain viewpoint like these communications do, one of the things I've seen that is oftentimes overlooked is the own government affairs and lobbying activities of the company. A couple of clients, large publicly traded companies, came to me and said, well, we want to be neutral. We want to be the Switzerland in Larry's slide. And the first thing I did was went to their website and saw that they had an active government affairs and lobbying practice for the issues of the company. And I think, and oftentimes I find that employers communicate those things to try to rally the troops of the employees, to understand that this regulation could put us out of business or might help us increase our business. And I think that adds even more complexity to how or what you say in these types of communications. Do you have any thoughts on that?
Sure, and if you recall, one of the things I discussed was, management needs to know what your policies are. By the same token, it's really important for management to know what the company's positions have been and what the company or entity's actions have been in furtherance of those positions. Because if you want to talk about egg on your face and lack of credibility and workforce in the general public who doesn't believe a word you say, making a statement that's directly contradictory to well-documented, publicly available lobbying efforts, for example, is going to do a lot more harm than the good that you're trying to do with your initial statements or directives.
Great. Well, thank you. I am also, and hang on, Larry, I'm going to skip my slides because this was like my fourth slide in my presentation. Larry was talking about public disclosures of what I'll call social guilt and what you're going to do to fix it. And in recent months, under the slide, no good deed goes unpunished, a number of very large companies have found themselves at the other end of Department of Labor inquiries about what you could argue is efforts of the government to crack down on these things, claiming that they are a form of discrimination. In June, Microsoft announced it would commit significant money and effort to increase the diversity of its staff. And Wells Fargo did the same. And then they get letters from the OFCCP, right? That is the agency of the US Department of Labor that supervises compliance with the executive orders on a. So you have to be a federal government contractor to be subject to that. But this almost like, okay, we've looked at, in light of social movements in America, we want to be more diverse and reflective of our society. We're going to do some things voluntarily. And now it seems as if the government is going to crack down on it and says, you can't do that. And it actually gets worse. On September 22nd, President Trump issued an executive order entitled Combating Race and Sex Stereotyping. This was an executive order focused on the executive branch of government and government contractors and government grantees in the sense that they're recipients of federal funds. The executive order itself, which is on the White House page website, is about 5 pages long, talks about the Gettysburg Address and the Civil War, talks about civil unrest, but focuses on what it purports to eliminate the promotion of race or sex stereotyping or scapegoating in the federal workforce. It goes into great detail on training programs that they discovered within various executive branch agencies where they thought it was almost like shaming Americans because there had been a history of race or sex discrimination. And the executive order contends that it prohibits divisiveness in the workplace, so we're going to ban it. Now, most of our attendees today are in the private sector, but if you are a federal government contractor subject to the affirmative action regulations under 11246, this new executive order becomes effective 60 days from its issuance, or November 21st, and the OFCCP has issued and is available on their website a series of questions and answers about what is race or sex scapegoating, which they define as any finding fault, blame, or bias to a race or sex, or to become members of a race or sex because of their race or sex. It encompasses any claim that consciously or unconsciously, by virtue of their race or sex, members of any race are inherently racist. What this was designed to attack is what is known as unconscious bias training, which increasingly has become part of corporate America training on anti-harassment and diversity and inclusion promotion. The Q's and A's go on to give examples. And this is very complicated and very perplexing to a lot of businesses because it seemed to come out of nowhere. And it seems to say if we voluntarily engage in certain activities, we could be punished. And so Larry started out by talking about the new normal. I don't think there is any normal anymore. There's a lot of turmoil and a lot of confusion, both in our society, and it's transferring over to the private sector in terms of how do I know what to do right or good by my workers, by my customers, and by my communities. I'm going to back up now a couple of slides. See, I got this down, Larry. I'm doing this pretty good. And that the new normal, of which there is no normal, is, in the old days, we went out and encouraged people, you got to have a policy statement, you got to conduct some sort of annual training. But in 2020, given everything we've just talked about, that's not enough. And anyone who is serious about having an effective diversity and inclusion program, you can't just focus on training and you can't just focus on hiring. You have to look at every component of what I call the employment life cycle, right? Now, normally when I do training, this is where I would break into the song, The Circle of Life by Elton John. I will spare you all that because I know the people working the controls would automatically mute my mic. But what I'm talking about is if you're going to have a successful diversity and inclusion program, you have to look at and analyze job creation, job structuring, recruitment and outreach, hiring, onboarding, and cultural integration. And by cultural integration here, I mean your corporate cultural integration, which can include mentoring and other types of activities. You have to then look at your compensation and pay equity. And since we can't see you, nobody needs to raise their hands. But how many people in the audience work in companies that seriously analyzes whether or not there's internal pay equity and pay discrimination? Similarly with promotion and terminations, as well as resignations and turnover. Why do people leave? Is there a problem here that we don't know about? And unless you carefully statistically analyze and measure each of the components of the employment life cycle, you will never have a good understanding of A, do you have a problem? And B, if you have a problem, how do you fix it and where does it reside? And that involves measurements and statistics. And if you're a federal government contractor subject to the Affirmative Action Executive Order and the other laws on affirmative action for disability and for veterans, you have to be mindful of complying with those requirements. But if you're not, it doesn't mean you can't do this, but you do not want to set hard goals or quotas because that can be the basis for a reverse discrimination claim, which apparently some people in the federal government are starting to focus on. But it doesn't mean you cannot hold management accountable. Unless you hold management accountable, and that's not just the HR person or the human resource person or the recruitment person, line management has to understand these things, these dynamics of the employment life cycle, and has to be held accountable for the results or lack of results that occur when seeking to broaden your diversity and be more inclusive. So what's the new normal? Again, I submit to you there's no normal, but looking at enhanced outreach and recruitment, eliminating things, subtle things in job postings that might unintentionally discourage a diverse candidate from applying, using statistics to analyze results and identify results in every aspect of your process, highlighting both internally and externally the success of your diverse employees, creating programs that promote community building inside and networking in opportunities, because so many organizations, even today, gain a large part of their new hires through internal recruiting and networking. And what I call real mentoring programs, not fake mentoring programs, where actual real mentoring and guidance is going on, as opposed to Larry will take me to lunch a couple of times a year and talk to me, how's it going? External things like scholarships and internships, and then not just annual anti-harassment training, but talking about all these things. And you say, well, Mark, you just told me if I do all these things, the OFCCP might come after me. I think it remains to be seen how this executive order shuffles out. There'll be some further regulation and guidance to see where this is all going. And of course, we're seeing companies, as a result of some of the societal issues that Larry's talked about, we're seeing employers facing increased demands to be diverse and inclusive, not only from their employees, but all their constituencies including customers, investors, and even the public at large. And what happens next from a purely legal perspective depends in large part what happens on November 3rd. I am not going to prognosticate in any way. And I'll tell you a funny story that Larry was witness to 4 years ago, exactly the day before Election Day. My office had an all attorneys hands-on meeting, and I thought to kick it off, we would have a discussion about what was going to happen the next day on Election Day. I put up a map of the Electoral College. I had read all the polls and 536 or whatever his name is. And we went into a discussion and I was so wrong. So I'm not going to predict now. But there is a lot of unknown. And from a pure legal regulatory, as you've seen through OSHA and the people who presented on the NLRB, if the administration changes, this is going to change. If the administration doesn't change, you're going to see a lot more of executive orders and other types of activity, including potential enforcement activity, going in a different direction and one we've never seen before. And so with that, now you get to hear from Krista Cabrera. Krista?
Hello. Hi, everyone. Sorry, I had the mute on, of course. All right, let me see if I can take these slides over. There we go. All right. So to finish out today, we just wanted to talk a little bit about what the future is going to look like in terms of return to work post-pandemic. And not to beat a dead horse, I think this may be the 5th time you're hearing this today, but the phenomenon we are all dealing with is the reality that jobs we previously thought could never, ever be done remotely, we have now learned oftentimes not only can be done remotely, but can be done remotely relatively seamlessly. And I just, found it interesting that Harvard Business School did a study of pandemic-induced remote workers and employers, and found that at least 16% of workers are planning to permanently switch from professional offices to working from home at least 2 days a week when the pandemic is over. So we're just looking at a huge swath of American workers not going back at all or going back on some sort of reduced schedule. And I'll tell you just, from personal experience, in February 2020, if asked, I would have said, no way, no how, never could I effectively conduct a remote mediation or a remote deposition, never. And today on October 13th, 2020, I'll tell you, I've done several of both totally effectively. And we've learned this in virtually every industry, that there are jobs that it turns out can be done really effectively remotely. So what does this mean going forward? Post-pandemic, when people choose perhaps to stay at home and perhaps we let them. We've talked about this. I don't want to repeat what we've already discussed, but we will be thinking a lot in the future about how we track productivity for employees who are remote. And I know both Dan and Rachel talked a little bit earlier about some wage and hour issues that have currently arisen from remote workers. But going forward, I think we're really, really going to have to put in place very effective technologies to track time for non-exempt employees. Because separate and apart from the question of how productive are non-exempt employees when they're remote and how do we figure that out, and I think there are going to be technologies put in place to answer that question. Including technologies, some of which already exist to determine how long, very big brother, by the way, but how long employees are away from the computer when they're on the clock. Are non-exempt employees and exempt employees, for that matter, truly being productive when they're away? But we've also got to be sure that with non-exempt employees, we continue to have them accurately track their time so that they are paid properly. And this is a really big issue in California where I practice, where, for example, we have meal and rest period requirements for non-exempt employees. And what I fear we will start seeing, what you want to be looking out for in the future in order to prepare yourself for coming class actions and hopefully take some steps so that those don't come down the pike, is, I fear we're going to have a situation where non-exempt employees are working remotely. They get really accustomed to working remotely, and they completely understandably, you know, at the end of the day, just type into their timesheet that they started at 8, they stopped at 5, and somewhere in there took a 30-minute meal period. And time records that look like that, like every single day the same, 8 to 5 exactly, 30-minute meal period exactly, are rife for challenge as being inaccurate and as being coerced. So you want to remind your non-exempt employees who are working remotely that they've got to clock in when they really actually start working, clock out when they really actually stop working, and take those meal and rest periods where that's required by law, which of course raises another question, which is how are we going to get non-exempt employees to take these breaks if we're not physically with them? And that's really all about communication. You need to make sure that you are reminding your non-exempt employees going forward, hey, you're working from home, but the company policy is that you must take a 30-minute meal period before the end of the 5th hour of work if you're in California. And here via email is a copy of that policy. If for some reason, you know, you're being inundated with emails, you're having a problem, you know, doing this, let HR know or let your supervisor know. So you want to make sure that there is a paper trail showing that these policies and practices are still in place even when employees are remote. And, you know, the same goes for overtime. I know a lot of companies, very understandably, have said no overtime to remote non-exempt employees. But, you know, off the clock claims were alluded to earlier in the day today. And if in reality, there is so much work that a non-exempt employee must put in overtime, that time's got to be tracked and that time's got to be paid, or you're going to be facing a class action lawsuit. And then, you know, the other way I think that we're really going to see productivity tracking is far more regular check-ins than you did when you were all physically, or should I say formal and scheduled check-ins than you saw previously when we were all together in the workplace and could just sort of spontaneously walk in and out of each other's offices. And I think it's very important that these happen regularly and that at least some of the time that these are on camera. You want to be able to check in on your coworkers. You want to make sure that they are actually okay, that they are actually getting work done. And you know, I think we're also going to see a lot more electronic monitoring, like task lists and production lists, you know, sort of ways that we can electronically show that we are moving the ball forward in terms of our job, that we're being productive, that we're doing what we need to do despite the fact that we are remote. Let's see, let's go to this next slide. This is an issue I've seen come up quite a bit lately, and I really think going forward, where the staycation becomes the new norm, it's something all employers need to be thinking about. You know, understandably, at the beginning of the pandemic, when we didn't really know how long we'd all be in this situation, a lot of people were saying, I don't want to take my PTO. I don't want to waste it. You know, I can't go anywhere, so I'm not going to take PTO. And I think, you know, sort of there are two equally bad results when that happens. Number one, employees don't take PTO and they get burned out now that this has been a long-term situation. Or number two, they take a day off, but they just don't actually use PTO in their PTO bank because they're not in the office. No one knows that I'm not here. Either result is bad, right? On the one hand, we don't want people burned out. Vacation is very important. People need to take their vacation. It's there for a reason. On the other hand, you don't want people, particularly in states like California, where we can't have use it or lose it policies, just sitting on growing banks of PTO that's either not getting used or people are taking PTO but not marking it down because they're not physically absent from the office. So I think it's super important as we go forward in this pandemic and with remote work that people realize they need to take their PTO. PTO exists for a reason. And even if it's a staycation or just, you know, going somewhere 2 hours away, that needs to happen. Computer needs to be shut down. you need to take a vacation. And I even know of some companies that temporarily, and again, understandably, at the beginning of the pandemic, took measures so that employees wouldn't be penalized for not being able to go on a real vacation. And they, for example, removed caps or let employees continue to accrue where otherwise they wouldn't if they didn't use down their vacation. And, you know, at this point in time, I think you've got to just stop those practices and tell people, take your PTO. This is a long-term situation and people need to take vacation. And the same goes for sick leave. You know, for a while, I think people were sort of putting off non-emergency medical appointments, dentist appointments, but that's all kind of gotten back to normal and people are doing those things again. And particularly in states where there are mandatory sick leave laws, that's covered by sick leave. And employees should be using their sick leave for that time instead of just sitting on a sick leave bank that never gets used down. So you should remind employees going forward, you know, if you go to the doctor in the middle of the day on a Tuesday for 2 hours, let HR know that needs to come, or put it on your time card. That comes out of the sick leave bank. It's there for a reason. It's there to cover medical appointments, preventative care, etc. And this is where I would invite you, Mark and Larry, to join me. What about the intangibles? I mean, this is sort of the great unknown. If we are all long-term going to be remote, what happens to mentoring? You know, mentoring is a hugely important aspect of most workplaces, and it's tricky to mentor from a distance. You know, what do you do about onboarding? I mean, I'll tell you, and I know this story, everyone's got a story like this. My sister moved to Manhattan to start a new job in early March, went in for 2 days, and then they shut down, and she hasn't been there in person since. She has since brought on 2 new people to work for her. So she's both been onboarded and onboarded others in a pandemic without physically meeting people she's working with. You know, how do you keep up your company culture, which is so important to so many companies, when everyone's remote and no one's physically in person? What do you do about socializing? I mean, you know, my assistant and my paralegal are really close. They used to go running every day at lunch. You know, how do you replicate that remotely? And then finally, teamwork. You know, many of us work on teams. We're used to seeing people on our team every single day. We've got almost a shorthand with each other when we're in person. And how do we make that work remotely? These are really these intangible questions that, as seamless as working remotely may seem to be in an emergency, you know, if this is going to be a long-term situation, we're really going to have to think about these things.
I would just add to that I think the answer to whether or not society, America, our economy has been more productive working remotely or less productive, I think the jury's out on that, and the true statistics haven't been analyzed. And in fact, it's very hard to analyze. I think a lot depends what we find out. If people are truly more productive or as productive, then we may never see the normal workplace we all thought of. But if in the end it's determined we're really not as productive as we think, and there's a better, and the old way was better, I think there'll be an eventual, once the COVID passes and hopefully no other pandemics, that we'll go back to the old ways to a large extent, but who knows?
Mark and Krista, I think, you know, a lot of folks have been proclaiming the death of the physical workplace, right? And I've seen a lot of prognostication that once, because at some point COVID-19 will be over, we just don't know when it is, that things have changed so dramatically that everyone's used to working at home and no one's going in the office. And I think because of the intangibles that you list here, those death sentences are a bit premature. Perhaps we won't be going in as much. Perhaps we'll have different work arrangements. Like you say, Mark, the jury is out, but there are certain intangibles you frankly just, it's not the same from at home. You brought up mentoring. how do you do it? I'll say personally, it's been a struggle, right? I have a mentee. He sits typically in the office right next to me. Up until March of this year, we would talk every single day. He would come over, he would bring his work. I'd look through it. He'd talk about his problems, what his challenges are. It was not happening as much, not in March, not in April. And what I finally had to do in May, because I realized it was a problem, was, and it's something you alluded to before, Krista, is if you look, and I wish I could share my Outlook right now, I have a Friday morning meeting set for an hour. Just every Friday morning, there's that 1 hour. At least I check in. At least it's still part of his week. It's part of my week. And to me, it's sort of the second best. It's still not as good as that spontaneity, but you do have to at least take affirmative steps to make these intangibles happen.
All right, that's all I've got.
And I think we're out of time. So who's ever the closers are could come up to the mound and close us out.
This is Carrie. My microphone was muted. My apologies. Last CLE code is up. So it's YD1DW first and foremost. And then we want to thank everyone for attending today. We understand the socially awkward nature of webinars versus what we had hoped to do in person at the House of Blues. Hope you found it informative. I know I did. Remember, you're going to be getting an email both on how to log for credit, and then we're also looking, if you can, make sure that you'll get a survey questionnaire from us as well. Please, we'd love some feedback if you have any to make. And then make sure that you get the let us know, and hopefully we'll be seeing you in person at the House of Blues in March of 2021. I'm getting a notice to remind everybody to remember to fill out their attorney affirmation form that was a link with the logon instructions that you got this morning. So again, last code is up. We thank you all for attending. Hope you found it informative.
Carrie,
and hopefully we'll,
the code's not up. We're not seeing the code and people are asking.
Oh, the code is YD1DW. Again, and it's in the link in the chat box as well. YD1DW. That's weird because it's showing up for me. So again, YD1DW. Anybody wants to email me, I'll help you out because it's not a problem. But we do appreciate you attending, and thank you very much.